Delivery of orders. Item number 1.
For reasons mentioned in the order, both the petitioners are allowed to be released on bail of rupees 50,000 each with certain conditions.
Deeply obliged. Deeply obliged. Next one, if you.
May please, Your Honor. The consent of the other side, I beg to mention item number 16, this for hearing today. That may kindly be taken upon some other day, my lord, some inconvenience to be.
15 is also same, my lord. 15 and 16, my lord.
Lawyers are different.
Lawyers are different, my lord. And my lord, as for my lord,
15, Mr. B. Sharma. 16, Mr. What is your name? Goswami.
15 G. Goswami, my lord.
15 G. Goswami. 15 B. Sharma. Learned counsel for the respondent.
In my case, appellant, my lord. In 16,
Appellant prays for an adjournment on the ground of personal difficulty of the conducting counsel. It is submitted that the learned counsel for the respondent have been informed regarding the prayer for adjournment, who does not have any objection to the same. Hence the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
My lord, I am appearing for the other side. Any date may be fixed.
No
That's
date.
old matter.
No date. 2 weeks.
What of?
what should be?
May please be, my lord. Lordship, I would like to mention for listing one IA for it is for that's 50% withdrawal, lordship. On
Next week.
Monday, lordship.
Okay.
And another for settlement has been arrived. So we have filed the IA. So that will be
Next week.
Monday.
Lordship, I would like to mention item number 20 of the daily list, Lordship.
I am for the respondent, Lord.
Yes, what is your prayer?
Lordship, the matter may be fixed on 23rd of June.
No, you can choose date.
Lordship,
You can pray for adjournment.
after 3 weeks.
Lordship, his senior
He's
has
in
given a leave application, no doubt, till 22nd. So, but the respondent is quite ill. So I need a accommodation, any date your lordship may feel.
Date any means it will go to August.
No,
We'll direct registry to list after 2 weeks.
Let it 3 weeks, Lordship.
Okay. Heard Mr. Z. Mukhi,
W on behalf of the
W. Hope, learned counsel for the appellant. Also heard Mr. A. Bishwas, learned counsel for the respondent. Learned counsel for the appellant has prayed for an adjournment on the ground of personal difficulty of the conducting counsel. Considering the grounds stated by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by 3 weeks on a date to be fixed by registry.
May I please, Lordship, beg to mention for listing of a MSc FPD, Lordship. Friday,
Which column?
Lordship. It's for hearing. Finally.
Hearing, no mentioning. Hearing, you have to pray before registry.
Lordship, it was last listed on 17/5/2024.
You pray before registry.
There is an interim IA is also pending, Your Lordship, for 50% disclosure. So both are there.
Orders column,
To be on
Order.
in order. Friday,
Ramesh at the date deo.
4/6.
24/6.
20. Next week, Lordship, we need it. On Monday, Lordship.
Next Friday. Next Friday.
Lordships. Listing of IA in MFA for payment of 50%.
Next Friday.
Next Friday.
Yes.
May it please your lordship. Your lordship, I beg to mention for listing of one RFA For orders, my lord. Of 2013, my lord. Kindly a date may be given, my lord.
4th, 4th of June.
Obliged.
May it please your lordship. Your lordship, I beg to mention listing of two MFA.
4th of June.
Much obliged.
May it please your lordship, I beg to mention MEC April 90/21. Your lordship, the matter may be released on 26 May.
Orders column. In which column? In order.
Hearing.
No, it will come to orders column. You cut the hearing. Mention it will be listed in orders column on 26th. Okay.
Obliged.
Your lordship, I beg to please I beg to mention item number 27. The senior engaged counsel is indisposed, so let the matter be.
Inform the other side.
Yeah.
What is your name?
Kagbishru Saikya. Kagbishru Saikya.
K. Saikya. Heard. You're for? Heard Ms. K. Saikya, learned counsel for the respondent, who prays for an adjournment on the ground that the conducting counsel for the respondent is indisposed. She submits that she has informed the learned counsel for the appellant regarding her prayer for adjournment. Hence, the prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry.
May it please lordship. Lordship, I beg to mention item number 5. Lordship, the learned counsel is out of station. Therefore I was instructed to pray for 2 weeks time.
Item number 5, you have informed the other side. We'll pass orders when the matter is called. Wait for your turn. Yes.
May it please your lordship mention for listing of MEC appeal, lordship, in orders to me.
4th of June.
May it please to your lordship, I beg to mention for listing a MSc appeal for orders next week, lordship, any date.
4th of June.
Obliged.
Orders, item 2.
May it please your lordship. Lordship, we had taken permission to give.
One by one.
I think আইটো আপোনাৰ তলত আছে আপুনি নহলে কৈ লওক মোৰ আপত্তি নাই কওক
There has to be some understanding. Yes, Miss Majumdar.
His lordship, we had taken permission to service notice on the respondent number 2 by Dusty, and lordship, that is, we have filed the affidavit at flag X. His wife has received the
How many respondents are there?
lordship. He is the owner and driver of the vehicle.
Okay. Heard Miss Adi Majumdar, learned counsel for the appellant. Also heard Miss D.D. Roy, learned counsel for the respondent number 1. Respondent number 1,
Yes.
claimant. Learned counsel for the appellant submits that the notice upon respondent number 2 has been served by Dusty Mode and in compliance thereto, and affidavit has also been filed by the appellant. I have gone through the affidavit filed by the appellants. With which the copy of notice is also annexed, wherein the signatures of the wife of respondent number 2 are there. The notice to respondent number 2 is therefore held to be duly served. The service of notice on the respondents is complete.
Else,
The-
we are received, Lordship, it can go for final hearing.
This matter is therefore ready for hearing. Let this matter be listed for final hearing when? Final
Lord,
hearing
I-
day. Ramesh, आता date दियो. 18th of August.
My lord, I have filed an IA, my lord, to release the amount, my lord, the awarded amount with interest. As my lord, this case was filed in 2019. They have taken one step only in that period. 6 years elapsed, they have not done anything, my lord.
Where is the IA?
And there was no stay petition, my lord.
Stay petition is not there.
They have not filed any stay petition, no stay was there.
Then you can go for execution. There is best.
That is why I filed, my lord, IA, because they have quoted a ruling, my lord, 2004 of Supreme Court. But in that ruling, the Supreme Court observed that owner, before releasing the amount, to take surety. But it is also observed that if in my lord,
Okay,
I
okay.
am not connected with the client is not connected with the owner. It is the responsibility of
That
the.
is the point to be decided in the appeal. We'll fix a shorter date. We'll fix it instead of you choose a shorter date, we will dispose of the appeal.
To sort that, my lord, because the claimant is.
Yes, Ms.
sick.
Majumdar suggested it.
If I do not have any option, only this second week of June, Lordship, I will not be there. From 7 to 13, 14. Other than that, Lordship can give any
25th June,
25th.
25th June.
Hello.
Item number 3.
Lordship, it was supposed to be listed for
It
hearing.
was in the hearing column, my lord. In fact, it did not reach on the last occasion. Therefore, it was mentioned, there's some urgency in the matter. This lady is my lord paralyzed from the my lord, the lower limbs are totally paralyzed, my lord, and she is suffering from various ailments because she's being bedridden. But there's some urgency in the matter. That's one that I may mention.
Heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. M. Datta, learned senior counsel assisted by Mr. Ainuddin, learned counsel for the respondents' claimants. It is submitted at bar that this matter has been wrongly listed in orders column. It ought to have been listed in the hearing column.
No, Lordship, it is listed in the orders column because they mentioned it.
We made a mention.
They have
Oh,
made
is
it
it?
by order.
We made a mention because my lord, there's some urgency in the matter.
By order.
And it is submitted at bar that this matter is ready for hearing. And this matter may be posted for hearing. Accordingly, when?
Can it be on 11th of June, madam?
I will be not there.
Okay. My lord,
No, June we don't have dates.
my lord,
15 June.
No.
Proceeding.
30 July.
But my learned friend says that she's in a very serious condition, Malad. So there's some urgent need of some the compensation, Malad, since.
Already 50% has
That's true,
given lordship,
that's true, but then
50% already
But
taken by them.
that's not sufficient, Malad.
But we have to fix it on a date when there is
Yes.
possibility of reaching the
Yes.
matter.
Here also same. thing.
Otherwise, same thing will
Yes.
happen.
But
So,
if the lordship permits me to make a mention on that day, Malad, for upgradation. That perhaps, Malad,
Gradation lordship,
let us see what happens on that day, 30 July,
30.
30 July,
30th of June.
July,
Malad, 13th or 30th?
30 July.
Zero. Malad.
Obliged.
Obliged.
Item number 4. Well, in this case, service is complete and TCR is also received. So, I pray that this will come up for hearing.
I don't one application is there.
Regarding,
IA 1678 regarding order 41 rule 27. For receiving the certified copy as evidence, additional evidence. And by the order dated 13/3/2026.
yes,
It was directed that if any objection need to be filed by the respondents, it can.
yes, are you objecting to it?
Yes, and I am objecting. My lord, lordship may take up along with at the time of hearing of at this application, my lord, because he
But-
wants to
my
adduce
lord-
the additional evidence.
My lord, this additional evidence will no way
No,
prejudice the claimant side. I am asking only for the seizure list, MVA report and route permit along with a copy of the policy to be
No,
exhibited.
no, why it was not reduced before the
Those route permit and the DL could not be arrived by the investigation report, the investigator could not submit that during the time of the trial and.
Why? If in spite of due diligence,
My lord, the route permit was manual and it has to be gone through the records. And during the course of the trial, it couldn't be got produced, but when it was given to the office and the report couldn't reach on time to the dealing advocate, and therefore the defense could not be taken up. And on producing the route permit, it was found that the route permit was not valid, and even the route the route direction is also not covered for the route issued by the authority. They deviated from that route.
no, suppose if your order 41 rule 27 petition is allowed, then they are entitled to cross-examine your insurance company. The claimant is entitled to cross-examine you on that point. For that matter has to go back to,
Exactly.
but provided your application is allowed, if you are able to show that the conditions mentioned in order 47 rule 27, order 41 rule 27 are fulfilled, was there due diligence on your part? Is it a new discovery?
We have mentioned it is a.
You filed written objection. We'll decide this issue.
yes.
Or we'll take it up at the time of hearing.
That will be
If we find that it is to be allowed, we'll send it back, remand the matter back. Okay. Heard Mr. C. Fukan, learned counsel for the appellant. Also heard Mr.
AK Gupta, my lord,
A.K. Gupta,
for respondent number 1, 2, and 3.
learned counsel for respondent number 1, 2, and 3. It is submitted at bar. Also Miss A.L.R. Young Thang, appearing for respondent number 4 and 5. Who are 4 and 5? 4 and 5. It is submitted at bar that this appeal is ready for hearing. However, learned counsel for the appellant submits that the appellant has filed an interlocutory application, that is IA number 1678/2024 under Order 47 Rule 27 of the CPC to allow the appellant to adduce additional evidence for bringing certain documents which have a bearing on the outcome of this appeal. Learned counsel for the respondent claimant submits that the application filed by the appellant under Order 41 Rules 27 may be taken up for hearing along with the main appeal during final hearing of the said appeal. Stop considering the submissions made by learned counsels. Let the make appeal number 245/2024 be listed for hearing on 27th August. The interlocutory application under Order 41 Rule 27 shall be considered at the time of final hearing of the appeal. List accordingly.
Obliged.
Highly obliged.
Item 5.
May it please Lordship.
Yes.
Lordship, the learned counsel is out of session. As I earlier mentioned it.
Why it is listed in
Lordship, TCR received.
ready for hearing? Heard, what is your name?
Lordship BJ Hajong.
BJ
Hajong.
Hajong, learned counsel for the appellant.
Sir, Lordship, appearing on behalf of L. Wajida.
Learned counsel appearing on behalf of Miss L. Wazida, learned counsel for the appellant. Also Miss B. Sharma, learned central government counsel appearing for respondent number 1, as well as Mr. T. R. Gogoi, learned government counsel appearing for respondent number 2 and 3. It is submitted at bar that this matter is ready for hearing, and accordingly it may be listed for hearing. Stop. Let this matter be listed for hearing 27th of August.
Item 6.
Please, Your Lordship. As per opinion noted 15 to 26, Lordship. Respondent number 2 and 3 duly served. And LCR is not received, Lordship. When respondent number 4 is yet not be served, Lordship, I think.
Heard, Mr. What is your name?
Yes, I tell him.
S.I. Talukdar, learned counsel for the appellant. Also heard Miss S.K. Begum appearing for respondent number 1. On perusal of the office note dated 15/5/2026, it appears that notice issued to respondent number 2 and 3 have been duly served. However, service report in respect of respondent number 4 is awaited. The registry is directed to place the postal track consignment report of notice issued to respondent number 4 by speed post before this court on the next date fixed. Staff registry shall also issue reminder for the records of the MEC case number 515/2021 from the concerned tribunal. Let this matter be listed again on
20th July.
28th July.
Hello.
Item number 7.
Office note dated 15/5/26, Lordship. No AD or unserved notice upon respondents. Lordship, AD is no, because this was postal, this track report can be given. And for 2, Lordship, it is received by professional service report. 2 is served. For 1, Lordship, registry may give the track consignment.
Heard Miss R.D. Majumdar, learned counsel for the applicant on perusal of the office note dated 15/5/2026. It appears that the notice issued to respondent number 2 has been duly served, whereas the service report in respect of notice issued to respondent number 1 has not yet received. Registry is directed to lay the postal track consignment report before this court on the next date fixed.
20 of July.
Let this matter be listed again on 20 July.
I'll oblige.
Next. Item number 8.
8 also same, Lordship. Office note dated 15/5/26. Unserved notice not received, and same order will be there.
You have gone through the office. Lord Miss R.D. Majumdar, learned counsel for the appellant on perusal of the, where is the record? On perusal of the office note dated
15/5/26.
15/5/2025. 26, it appears that the service report in respect of the notices issued to respondents.
Number 2.
Number 2.
2 is served. Same order.
Let me go through the
Yes.
next item. Matar. Next item. Call.
Sorry.
None has appeared for the appellant on call. Let this matter be listed in the next week on a date to be fixed. Yes.
Your Lordship, kindly pass over the matter for time being.
After some time. 39 after some time.
Oblige.
Item 40.
Also, this matter should come under hearing column also. It's here is also.
My lord, in this matter, a stay is operating in this matter, and I am unable to go for execution if a short date may be fixed in this matter.
Record.
Which is your question?
Heard Mr. K. Gogoi, Leonard, Central Government Council, appearing for the appellant. Also heard Mr. D. Rathi, Leonard Counsel for the respondent. It is submitted at bar that this matter is ready for hearing. Accordingly, let this matter be listed for date at 27th August.
Item 41.
None has appeared for appellant on call. Let this matter be listed in the next week on a date to be fixed by registry.
Item 42.
May I please, Your Lordship?
With your phone.
My lord, this record, lower court record has come, my lord. And this is, my lord, I have filed this, my lord, appeal, my lord, against the, my lord, order passed.
Who is appearing for the,
My lord, the legal aid counseling is appearing for the other city.
who is that? Is it ready for hearing?
It is ready for hearing, Lord. TCR has come.
Heard Mr. U.J. Sakyal and counsel for the appellant. None has appeared for respondent, though name of Learned Legal Aid Counsel. Who is Raju Devri? Learned Legal Aid Counsel has been reflected in the cause list. It is submitted by Learned Counsel for the appellant that this matter is ready for hearing. Accordingly, list this matter for hearing on 6th of August.
Item 43.
As per office note dated 15/5/26, postal consignment report, Lordship, service is complete. Otherwise, this is a delay petition, Lordship.
How much delay?
76 days, Lordship. Office note 15/5/26.
Heard Ms. R.D. Majumdar, Learned Counsel for the applicant. On perusal of office note dated 15/5/2026, it appears that notice issued to the respondents by speed post has been notices issued to the respondents by speed post have been duly delivered to the addressees. The notices are therefore held to be duly served. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant Messrs. Oriental Insurance Company Limited. Now, the Oriental Insurance Company Limited, paying for condonation of delay of 76 days in preferring the connected MAC appeal, whereby the judgment and order dated 24/10/2024 passed by the Motor Accident Claims Tribunal Sonipur in MAC case number 11/2022, 111/2022 within bracket D has been impugned. The appellant, where is the reason for delay?
Paragraph 3 to 7, Lordship.
The applicant has stated the reasons for delay in paragraph 3 to 7 of the instant interlocutory application. I have gone through the reasons cited by the applicant in the interlocutory application. Same appears to be sufficient cause which prevented the applicant in preferring the connected appeal within the prescribed period of limitation. As such, the delay of 76 days in preferring the connected appeal is hereby condoned and this interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it.
Hello, please, Lordship.
May I please, no, so item number 39, Lordship, I have missed, my name may kindly mention.
Item number 39, name of Mr. A.R. Agarwala may be reflected.
That is fixed for hearing, Lordship.
Is it ready for hearing?
Yes.
Key order? What order?
Right,
Heard Mr. A.R. Agarwala, learned counsel for the appellant. Also heard Ms. D. Goswami, learned counsel for the respondent. Respondent number? Respondent insurance company. It is submitted at bar that this matter is ready for hearing. Let this matter be listed for hearing on
20 August.
20th of August.
Much
Obliged.
Admission item 38. Lordship, I have been informed, my lord, the learned counsel R. Goswami is on leaves. Kindly pass on for the time being.
What is the issue?
Issue, my lord, while preferring an appeal under section 30 of the Employees Compensation Act, there is a requirement of submitting a
Okay. That we'll take it up after. That deposit of money,
before the tribunal,
the proviso.
the 30, section 30 provision.
Yes.
Your Lordship, kindly pass over the matter for timing.
Okay. We'll take it up after some.
Obliged, Lordship.
Hearing item number 9.
Eight, Lordship, they could not find the file on item 8, Lordship.
Ramesh. Adhiraj, item number 8. We could not locate. We'll take it up after some time.
Office note 15/5/26.
Ms. R.D. Majumdar, learned counsel for the applicant. Office note dated 15/5/2026 shows that notice issued to respondent number 2 has been duly served, whereas service report in respect of notice issued to respondent number 1 has not yet returned. The registry is directed to no. On both it is served.
Oh. Then lordship, it is a delay petition lordship. 73 days lordship, delay.
Okay. Heard Ms. R.D. Majumdar, learned counsel for the applicant. On perusal of office note dated 15/5/2026, it appears that from the postal track consignment report of the notices issued to the respondents, it appears that notices were duly delivered to both the respondents. Hence, notices issued to both the respondents are held to be duly served. This interlocutory application has been filed by the applicant namely Oriental Insurance Company Limited, under Section 5 of the Limitation Act for condonation of delay of 73 days in preferring the connected miscellaneous first appeal, whereby the judgment in award dated 8/8/23 passed by the Commissioner, Employees Compensation, Nogam, in case number NEC within bracket WC 49/2005 has been impugned. The applicant has stated the reasons for delay in preferring the connected appeal in paragraph number
3 to 7 lordship.
3 to 7 of the instant interlocutory application. After going through the said paragraphs, this court is of considered opinion that the applicant was prevented by sufficient cause in preferring the connected appeal within the prescribed period of limitation. Accordingly, the delay of 73 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. Registry is directed to register the connected miscellaneous first appeal and list the same for admission after a week on a date to be fixed by it.
Alia Black.
Item number 10. Item number 9.
9. Ramesh, any sheets আছে নয়? দিও।
Item 9.
পানি দিব দিও Nepal flags নতুন দিয়কচোন Yes.
Lordship. Lordship, the judgment is at, it starts from page 10 of my memo of topic. Main judgment starts from 11. In our appeal, Lordship, what we are challenging is the income taken by the income taken by the court when there was no proof of income, Lordship. Then, Lordship, interest on future prospect. Then, Lordship, about that, Lordship has passed a judgment recently wherein I was there about that pay and recovery, Lordship. I have that judgment. So, on that point. And then, Lordship,
Mainly interest on future prospects,
and income.
assessment of income.
Income. Lordship, in this judgment, Lordship passed, I'll just interrupt on that. Only thing, Lordship, some clarification to the extent that since the insurance company is paying the amount, they have, as per the judgment, because we have challenged the judgment. If that clarification is not there at the end, Lordship, that we can recover, file a petition and recover. So, Lordship, we might face some difficulty because the tribunal will feel that the case has been interfered by the High Court.
I'm not getting you.
Yes, Lordship. Lordship, this, I'm talking about this Saraswati Hallow judgment, Lordship passed on pay and recovery, Lordship. In that, Lordship, Lordship, everything is fine. Though it is not fine, but but Lordship, only thing my humble request will be, Lordship, in the end, Lordship, if it is mentioned that since the insurance company is depositing the amount, they can recover it as per Nanjappal from the tribunal, because tribunal.
As per Nanjappal or as per Swaran Singh?
As per Swaran
Swaran Singh also says that you
Yes.
can file an application before the.
Yes. Swaran Singh, however, Lordship, that only that one line will make it easier for the insurance company. Because otherwise, Lordship, the owners, they do not appear here, but they start troubling, they avoid notice and they avoid everything from the, that is the point because of which the appeals are filed, and so that there is a protection given by them. That is the only humble subject.
The only clarification which Apex Court has given that instead of filing a new suit for recovery, you can file an application before the tribunal
Yes,
in
exactly.
the said execution proceeding itself. Only that much is okay.
Only that much. Because, Lordship, otherwise the tribunal will think that already High Court has interfered and not given. So that is the only clarification needed. Now, Lordship, about the quantum of compensation, Lordship. Because on future prospect, in future prospect also, that same judgment, Lordship has interfered, mentioning all the other judgments of our High Court. Future prospect, they won't get.
Interest they will not get the interest.
Interest on future prospect, not future prospect, interest on future prospect. In fact, Lordship, the claimant Makon Hajarita, she had died and her children were made party. They were made party. So, Lordship, I'll just read the judgment from para 20, Lordship, because there the from the at para 20, Lordship, the income is discussed by the court. Before that, Lordship, or should I read the whole judgment, Lordship?
No, para 20 will do.
The claimant Srimati Makon Hajarika in her claim petition claimed an amount of rupees 25,71,000 for the death of her husband, late Hemo Hajarika, in motor vehicle accident. The claimant has stated in her evidence on affidavit that at the time of death, her deceased husband, late Hemo Hajarika, was 50 years old, and professionally he was a self-employed fish seller under Tinsukia Borbil Min Silpa Samabai Samiti Limited, Rongamati. Besides this, he was a member of the Brahmaputra Fish Sellers Cooperative Society, Rongamati. The monthly income of the deceased husband was about 10,000 from his income. He could maintain his family of 6 members, including 1 college and 2 school-going children nicely, and his future prospect was bright. The deceased was the only bread earner of her family, and at the time of death, her deceased husband left behind him his wife, that is the claimant, and 2 sons and 2 daughters as his dependent. But the claimants have not submitted any documentary proof in support of the age and income of her deceased husband. This will be important, Lordship. Though the claimant has exhibited one certificate, Exhibit 7, issued by the President Tinisuki Borbil Min Silpa Samabai Samiti regarding the profession of her deceased husband, but the claimant has failed to prove that certificate by adducing evidence of that issuing authority. This will be important, Lordship. Therefore, I find that Exhibit 7 has no any evidentiary value. The claimant CW1 has exhibited the post-mortem report of her deceased husband as Exhibit 4, wherein the doctor who conducted post-mortem examination on the dead body of the deceased has recorded the age of the deceased as 50 years. In absence of any documentary proof regarding the age of the deceased as mentioned by the doctor in postmortem report Exhibit 4 has to be presumed as true, and accordingly the age of the deceased is assessed as 50 years at the time of his death. In absence of any documentary proof regarding the income, Lordship, this will be important, and profession of deceased, I am of the view that the healthy and young person at the age of 50 can easily earn an amount of rupees 6,000 per month. Accordingly, the monthly income of the deceased is assessed at rupees 6,000. This is we are challenging, Lordship. Having assessed the monthly income of deceased at rupees 6,000, I would like to add 25% of the same as future prospect, since the age of the deceased was between the age group of 40 to 50 years at the time of his death. As he was a self-employed person, in view of the decision of the Honorable Supreme Court laid down in the case of National Insurance Company Limited versus PROCEEDINGS and others, reported in so-and-so. After addition of 25%, the amount would be 6,000 plus 1,500, 7,500 per month. The deceased at the time of death left behind his wife, that is the claimant CW1, and his 4 children to succeed his estate. So the deduction towards personal and living expenses of the deceased would be 1/4 of the above, in view of the law laid down by the Honorable Supreme Court in the case of Sarla Verma and others versus DTC so and so. And after deduction of 1/4 of above, the amount would be rupees so and so 5,625. The multiplier applicable here in this case would be 13, since the age of the deceased was 50 years at the time of accidental death. After this, the amount would be 5,600 so and so 8,77,500. Besides this, I would like to award a sum of rupees 15,000 under the head of loss of estate, another sum of rupees 40,000 under the head of loss of consortium, and also another sum of rupees 15,000 being funeral expenses in view of the decision of the Honorable Supreme Court laid down in the case of National Insurance Company Limited versus PROCEEDINGS and others. It further reveals from the case record as well as documents submitted by the claimant that the accident took place on 7/5/2015. Immediately after the accident, her injured husband Hemo Hajarika was taken to Dhemaji CHC, Dergaon, and thereafter at Jorhat Medical College and Hospital, Jorhat. But due to non-availability of ventilation facility in the said hospital, the injured Hemo Hajarika was referred to Gauhati, and accordingly he was shifted to Gauhati Medical College and Hospital in an ambulance having ICU facility and treated there in the ICU with ventilation for 25 days from 8/3/2015 during the course of his treatment. The injured succumbed to the injuries on 2/4/2015 in Gauhati Medical College and Hospital. The claimant CW1 has stated in his evidence in affidavit that she had already sent rupees 3 lakh for medical spent about rupees 3 lakh for medical treatment of her husband, deceased husband. But the claimant has submitted the medical expenditure statement exhibit 9 for an amount of rupees 89,983. Enclosing therein 46 numbers of original cash memo and bills from serial 1 to serial 46. I have gone through the same carefully and it is found to be correct. Thus, the claimant is entitled to a total amount of rupees 10,37,482 only as compensation here in this case. Now, the question arose from whom the compensation amount should be recovered for payment to the claimant. In the initial instant proceeding, the OP number 2 adduced evidence of Sri Pradeep Kumar Singh as DW1. From the evidence of DW1, it reveals that he is the administrative officer of Oriental Insurance Company Limited, Jorhat branch. In his evidence on affidavit, he has clearly stated that at the relevant time of accident, the OP number 1, Sri Moloy Bora, that is the owner cum driver of motorcycle bearing registration number so-and-so, did not possess a valid and effective driving license. They had appointed one Sri Sudipta Thakur, investigator, to investigate the genuineness of the driving license number so-and-so of the driver Sri Moloy Bora. During investigation, the investigator visited the office of CTO Transport of Sibsagar and confirmed that the driving license number so-and-so was not issued from the office and it was found fake. DW1 has exhibited the relevant insurance policy as Exhibit A. The OP number 2 has also adduced evidence of Sri Sudipta Thakur, the investigator of Oriental Insurance Company Limited as DW2. The evidence of DW2 reveals that he has investigated the genuineness of the driving license bearing number so-and-so of driver Sri Moloy Bora, OP number 1. During investigation, he has visited the office of VTO Sibsagar and found that the aforesaid driving license number so-and-so was not issued in the name of Moloy Bora, the driver of the insured vehicle bearing registration number so-and-so motorcycle. In this regard, the TTO Sibsagar has issued a report to him stating that the said driving license number so-and-so was not issued in the name of Sri Moloy Bora and accordingly opined that the same was fake as per record. To substantiate his evidence, the DW2 exhibited Exhibit B, the investigation report, and Exhibit C, the report of DTO Sibsagar. The OP number 2 has also adduced evidence of another witness, namely Orupjyoti Bora, Junior Assistant Officer of DTO Sibsagar as DW3 From the evidence of DW3, it reveals that as per office ledger book which he brought with him at the time of evidence, reveals that DL number so-and-so issued on so-and-so was not in the name of Moloy Bora, but in the name of Srinivas. According to the Register of District Transport Office, Sibsagar, driving license submitted in the name of Sri Moloy Bora is a fake one. Though the learned counsel for the claimant has cross-examined the aforesaid witnesses at length, but the factum of genuineness of driving license bearing number so-and-so of Sri Moloy Bora could not be established. Thus, from the evidence of DW1, DW2, and DW3, it reveals that at the relevant time of accident, the driver of the offending vehicle bearing registration number so-and-so did not possess a valid and effective driving license. But in the light of the decision of Honorable Supreme Court in National Insurance Swan Singh and others reported in Swansea, it is held that onus is always upon the insurance company to prove that the driver had no valid driving license and that there was breach of policy condition. When the driver did not possess the valid driving license and there was breach of policy condition, pay and recover can be ordered in case of third-party risk. The tribunal is required to consider as to whether the owner has taken reasonable care to find out as to whether the driving license produced by the driver does not fulfill the requirement of law or not will have to be determined in each case. Also, in the light of judgment of the Honorable Supreme Court in the case of National Insurance Company Limited versus Baljit Kaur and others reported in AR so and Dadappa and others versus Branch Manager National Insurance Company reported in and considering the fact that at the relevant time of accident, the offending vehicle bearing registration number so was duly insured with OP number 2 Oriental Insurance Company Limited by policy number and it was held valid up to 15/10/2015. I am of the view that the OP number 2 Oriental Insurance Company Limited Nagaon branch shall first pay the aforesaid awarded amount of compensation to the claimant along with simple interest at the rate of 6% from the date of filing of the claim petition till realization of the entire amount and to recover the same from the OP number 1. The issue number 2 and 3 are decided accordingly in favor of the claimant. In the result, the claim petition is allowed on contest. The OP number 2 Oriental Insurance Company Limited is directed to pay the amount of rupees so and so only to claimant along with simple interest at the rate of 6% per annum from the date of filing of the claim petition. That is from so and so till realization of the entire amount with liberty to recover the same from OP number 1. The OP number 2 shall deposit the awarded compensation along with interest thereon in the claims tribunal within 30 days from date of the judgment. It is further ordered that out of the aforesaid awarded amount, rupees 1 lakh each shall be kept in fixed deposit scheme in the name of minor son Pankaj Hajarika and minor daughter Miss Dipjyoti Hajarika of the claimant in a nationalized bank nearest to their house till they attain their majority, and rest of the amount shall be paid to the claimant. Let a copy to be served, Lordship. Sent to OP Molloy Bora, son of so.
Have you deposited any amount?
Yes, my lord.
Yeah.
On the day of admission, my lord, there have been
75%.
75% was directed to be deposited. But the sad part is that I am not in a position to withdraw it.
Why?
My lord, I have filed an application for withdrawal. They have objected. Thereafter, NCR comes.
It is
It are
still
posted
there.
for hearing.
Okay. Now, what is your submission?
Now my submission, Lordship, as I submitted that day also, those Nanjappan that the court should have followed, Nanjappan, though Lordship has.
That day's argument I don't remember.
Okay. Lordship. Here.
That first notice should go.
No, Lordship, Swan Singh case, Lordship, I would like to just hear. Swan Singh is, there are two things. Here in this case, Lordship, the owner himself was driving the vehicle. So the knowledge of DL, what was discussed by the tribunal in that paragraph, Lordship, that the owner had the knowledge about the driving license. It is different from when the owner himself is driving the vehicle, Lordship. That is one part, Lordship. And
no, the tribunal has held that there was a breach.
yes,
And therefore you are not,
we can recover.
you can recover.
Yes.
On that you have
Lordship. Today
the findings of the tribunal. You are aggrieved mainly with the imposition of interest on future prospects.
and pay and recovery also, that is one of our ground. Pay and recovery and our grounds, Lordship, I am going to. First is, Lordship, income. We have said that the court without any proof, I have read.
Yes, the tribunal held that though he failed to adduce any evidence,
6,000 was taken as income. Recently,
taking him to be a able-bodied person.
Recently, Supreme Court has given a judgment, Lordship, but I do not have that judgment right now. I could
What it says?
that the wages, minimum wages notification is to be taken of that time, Lordship. It was in 2015, and I think in 2015, Lordship, it was 100 and something, Lordship. Minimum wage per day. So that's why in ground number A, we have said that 3,000 ought to have been taken as notional income.
How much?
3,000, Lordship.
Okay.
B, Lordship, that interest given on future prospect. Our ground number B is interest given on future prospect, which is not entitled to.
Yes.
C and D, Lordship, are about the DL, that pay and recovery that has been given, and E also. C, D, and E are on that, Lordship. And F, Lordship, is on the fact that if the amount is directed to be paid without any security from the owner, Lordship, then it becomes very difficult for the insurance company to recover that amount, Lordship.
No, there is no bar in taking security. That we can direct, but withholding the payment is the difficulty.
Lordship, but this judgment, Lordship passed, Lordship, in MSc appeal that day, Lordship, in that portion is not there. That
There is some observation that
Lordship discussed with Japan.
no, there is some observation that in peculiar facts and circumstances of a particular case, court may direct deposit of security also. But withholding payment to the claimant during that period does not seem to have any basis. I have not said that does not seem to have any basis. Read that specific paragraph. Your submission is that security should be deposited. Till then, payment, the amount should not be disbursed.
Yes.
As per Nanjapan.
Yes. But Lordship explained that that amount should not be held back for the claimant. But Lordship, the rest of the part that the security, the tribunal will do as per Swan Singh or Nanjapan, Lordship.
Yes.
That
there is no bar.
There is no bar, but that is not mentioned in this judgment, Lordship, by Lordship. So that can be added in the present case. So Lordship has said that there is no bar, there is no clarification need to be given in view of Swan Singh's judgment.
Yes.
Lordship had mentioned in this, Lordship. But then, Lordship, what my prayer is that only one or two sentences on that line, that the tribunal will do as per, because Lordship, I've submitted our own High Court judgment. Lordship has descended from there, that Purnima Kumari judgment, wherein another judge, Lordship, mentioned about Nanjapan thing, like how to be done. But since Lordship is just diverting a bit from that, so Lordship, and my prayer is Lordship will mention that the tribunal will do the needful as per Swan Singh or Nanjapan. But here also during argument, Lordship, I am mentioning the same judgment and I am also mentioning Lordship's judgment. So, and about the quantum of compensation, Lordship, the 3,000, Lordship, it is not proved. Lordship, the tribunal has itself at paragraph 20, I read, Lordship, that they exhibited some document, but the author is not examined. So the insurance company did not get an opportunity to, and that certificate is also not a certificate of income. That certificate is,
No, that is not relevant because tribunal has not relied upon that document.
yes,
Tribunal
but it
has
went on
made
to,
a guesswork that as a able-bodied person, he would have earned 6,000 and
that is what I'm, Your Lordship, the Supreme Court judgment, I'll give the judgment, Lordship, before Lordship passes the judgment, that the minimum wage is to be, and it is for the insurance company to mention.
yes.
It is given the direction that the insurance company should mention about the minimum wage. Minimum wage.
Yes.
I'm
No,
just-
later on you may give that judgment.
No, I'm just in that year, how that judgment is. That judgment is, Your Lordship. Okay, I'll give which letter that the minimum wage is to be taken.
Yes, Mr.
That page.
Mr. Datta.
Yes. My lord, here in this criminal make appeal, lordship, I have preferred also one cross objection.
Cross objection is there.
Yes. Cross objection is there for enhancement of compensation. My lord. Cross objection, my lord, 17, 2022.
Okay, what are the grounds?
My lord, cross objection, my lord, my ground number, my lord, 2, my lord.
Yes.
For that, my lord, the learned tribunal held that Exhibit 7 has no any evidentiary value. But on the other hand, from Exhibit 8, it clearly reveals that the deceased was engaged with fish farming. Exhibit 8 is the certificate issued by National Federation of Fishermen's Cooperatives Limited, New Delhi, regarding participation of 10 days training program for fish farmers, organized with the financial support of Ministry of Agriculture, so and so. Moreover, the involvement of the deceased in fish farming, fish selling is not denied by the insurance company during cross-examination of CW claimant. As such, the profession of the deceased as fish farmer has duly proved. And in such view of the matter, dishonorable court may be pleased to assess the monthly income of the deceased at rupees 10,000 per month instead
No,
of.
on what basis?
My lord, it is an admitted fact, my lord, that I am my lord, fish seller, my lord. I am dealing with fish farmer.
Okay, assuming that you are a fish seller.
Yes, sir. Assuming that, my lord, my income of the deceased ought to be considered as 10,000 instead of 6,000.
No, on what basis? Merely because you are a fish farmer. There may be categories of fish farmer.
No, but my
Some
lord,
fish farmers may earn lakhs of rupees monthly.
that is there. But
Some may earn less than 5,000. So there is no proof. You have not reduced any evidence regarding the
problem is that, my lord, as because, my lord, I am not but a deceased was not an income tax assessee. So therefore, my lord, it becomes very difficult on a part of a, my lord, such type of petty businessman, my lord, to prove his income because he is not an income tax assessee. Otherwise, if you do it an income tax assessee, my lord, then, my lord, it would be possible. But, my lord, as he was.
how this court will come to a finding that it is not 6,000, it is 10,000. On what basis?
My lord, because, my lord, it is an admitted fact, my lord, he is dealing with, my lord, fish selling. Admittedly, my lord. And, my lord, a fish farmer, my lord, at that relevant point of time, maintaining a family consisting of, my lord, 6 persons, my lord. All of them were two of them were studied in a college. So, my lord, income of 10,000, my lord, it was quite, my lord, my lord. So therefore, my lord,
Ministers.
on that ground, my lord, on that context, my lord, because some, yes. Next, my lord, the tribunal committed error, my lord, ground number 3, my lord. Or that the learned tribunal committed error for granting rupees 15,000 compensation under the head of loss of estate and funeral expenses, which ought to have been rupees 16,500. Because, my lord, as per my lord pronoicity judgment, my lord, that from my lord every 3 years, my lord, it will increase to my lord 10%. So in that view of the matter, my lord, it was when I filed it, my lord, at the time of, my lord, the pronouncement of the judgment, my lord, it ought to have been 16,500. Now it definitely it will increase, my lord. Because, my lord, promissory judgment, it says, my lord, that the compensation, my lord, under this conventional heads, my lord, that will increase every 3 years, my lord, after every 3 years. Next, my lord, ground number 4, my lord, may kindly see. For that in legal parlance, consortium is a compendious term which encompasses spousal consortium, parental consortium, and filial consortium. In the instant case, only a sum of rupees 40,000 is awarded under the head consortium. But the learned tribunal ought to have awarded 44,000 under the head spousal consortium and rupees 88,000 each payable to the children of the deceased Pankaj Hazarika, Deepjyoti Hazarika under the head parental consortium. Because, my lord, that at relevant time, Sri Pankaj Hazarika and Ms. Deepjyoti Hazarika was minor. As such, the award passed by the learned member of the tribunal need to be enhanced on that count.
Okay.
And, my lord, the ground number 5, my lord, tribunal awarded 6% interest upon the awarded amount from the date of filing of the claim petition, that is from 23/4/2015 till realization of the entire amount, which is very much inadequate and needs to be modified at the rate of 9% amount per annum. My lord, to that effect, my lord, I place one judgment, my lord. My lord, here I have prepared one, my lord, a written argument, my lord, small written argument, and I have placed certain judgments in support of my case, my lord. That is forensic, and forensic I have placed. Then, my lord, I have placed that Nanjappa. P2 most of Gutekida Mai.
Okay.
No, definitely. If you want, then I can. My lord, I have relied that Swaran Singh judgment, then Nanjappa, and following that Swaran Singh judgment, my lord, many Supreme Court judgments, my lord, which hold that, my lord, that in spite of, my lord, there is a violation of policy condition, my lord. In that event also, my lord, to protect the interest of the, my lord, third party, my lord, tribunal can direct, my lord, to deposit the amount, pay the amount first, then they can go for, my lord, recovery. My lord, to that effect, I have placed certain judgments. My lord, may kindly observe one thing, my lord, that, my lord, that Swaran Singh judgment, my lord. My lord, Swaran Singh judgment was passed by, my lord, 3 judge benches, my lord. 3 judges, my lord.
Yes.
And, my lord, it was, my lord, the Swaran Singh judgment was passed on, my lord, 5th of January 2004. My lord, may kindly note, my lord, this was passed on 5th of January 2004. And in that judgment, my lord, may kindly see, my lord, I have marked, my lord, the page 341 of that judge compilation, my lord.
Yes, what you want to
Yes,
say?
my lord, that summary of findings, my lord. my lord, I just point out the summary of findings, my lord, ground number 3, my lord. That, my lord, under the, my lord, paragraph 110, my lord.
Yes.
My lord, that says, my lord, the page 341 of the case. Soren Singh's judgment.
Yes.
That says, my lord, the breach of policy condition, example, disqualification of the driver or invalid driving license of the driver as contained in subsection 2A2 of section 149 has to be proved to have been committed by the insured for avoiding liability by the insurer. Mere absence of fake or invalid driving license or disqualification of the driver for driving at the relevant time are not in themselves defenses available to the insurer against either the insured or the third parties. To avoid its liability, this is important, my lord, towards the insured, the insurer has to prove that the insured was guilty of negligence and failed to exercise reasonable care in the manner of fulfilling the condition of policy regarding use of vehicle by a duly licensed driver or one who was not disqualified to drive at the relevant time. So, it is the burden of the, my lord, insurance company, my lord.
Okay.
And, my lord, and here, my lord, I will come, my lord, that the insurance company has failed to prove that burden, my lord, failed to discharge that burden. I will come later, my lord. Then, my lord, may kindly see, my lord, 110.6, my lord, findings number 6.
Yes. No, how the insurance company failed to prove
My
delay.
lord, I will come, my lord. Just before that, my lord, may kindly, my lord, 6, my lord, it says, even where the insurer is able to prove breach on the part of the insured concerning the policy condition regarding holding of a valid driving license by the driver or his qualification to drive during relevant period, the insurer would not be allowed to avoid its liability towards the insured unless the said breach or breaches on the condition of driving license is or are so fundamental as are found to have contributed to the cause of accident. The tribunals in interpreting the policy condition would apply the rule of main purpose and the concept of fundamental breach to allow defenses available to insurer under section 149(2)(a) of the Act. So, my lord, then, my lord, may kindly see, my lord,
What it means.
my lord, it means, my lord, suppose, my lord, the insurance company is able to prove
There is a breach.
there is a breach.
Yes.
In that event also, my lord, the tribunal can pass an order of making the payment to the claimant. Then they can go for, my lord, recovery, my lord. From this, my lord, the findings, my lord, from 1 to, my lord.
No, it does not mean that. It says if the breach is so fundamental
Yes.
that if breach is not a fundamental breach, that you read that, then the tribunal the insurance company cannot escape its liability.
Yes.
It is so fundamental as are found to have contributed to the cause of accident.
Yes.
If accident has been caused for some other reasons,
Yes. Yes.
then tribunal is liable to pay. It cannot shift its burden to the owner.
Yes.
But if it is not so, then tribunal may pay but can recover it from the owner later.
Yes. Yes.
The example of this will be lordship if there is a
Brake
brake
failure.
failure, puncture.
Yes.
So
Yes.
if accident is because of that, but here in our case, this is not relevant.
Yes.
Because already he made someone die.
My lord,
So if accident occurred due to some mechanical failure where driver was not at lapse, then tribunal cannot, then insurance company cannot escape its liability, showing that there is a breach of policy condition in
Yes.
not having valid license.
yes,
But otherwise, the liability shifts to owner.
but my lord, that my lord, that three, my lord. That finding number three, my lord.
Yes.
Or my lord may kindly see the ground number 10, my lord, findings number 10.
Yes.
10. Whereon adjudication of the claim under the Act, the tribunal arrives at a conclusion that insurer has satisfactorily proved its defense in accordance with provision of section 149 to read with.
That is their case.
Yes.
That they are saying that we have satisfactorily proved the breach of policy condition, therefore we are not liable to pay. They are mainly saying we are not even liable to pay at the first instance. Take it directly from the owner.
Yes, yes, I will come, my lord. But my lord may kindly, I am just reading again, my lord, for a moment, when I am reading once again, my lord, the 10, my lord, ground number 10. Whereon adjudication of the claim under the Act, the tribunal arrives at a conclusion that the insurer has satisfactorily proved its defense in accordance with provision of section 149(2), read with subsection 7 as interpreted by this court above. The tribunal can, this is important, tribunal can direct that insurer is liable to reimburse by the insured for the third party under the award of the tribunal. Such determination of claim by the tribunal will be enforceable, and money found due to the insurer from the insured will be recoverable on a certificate issued by the tribunal to the collector in the same manner under section 174 of the Act as arrears of land revenue. The certificate will be issued for the recovery as arrear of land revenue only if, as required by subsection 3 of section 168 of the Act, insured fails to deposit the amount awarded in favor of the insurer within 30 days from the date of announcement of the award by the tribunal. So this is, my lord, if the insurer failed to deposit that, my lord, in that event, my lord, they can go for, my lord, that's 174 under for arrears of land revenue, my lord. They can go for it. So, my lord, but there is no bar to direct the insurer to reimburse by the insured for compensation, my lord. So, on that footing, my lord, the judgment of the, my lord, tribunal, my lord, directing the, my lord, the insurance company to pay and then to go for recoveries, my lord, as per my humble submission, is correct, my lord. Next, my lord, may kindly see the Nanjappa judgment, my lord. It was passed, it was delivered subsequent to that Swaran Singh, my lord. My lord,
Yes.
Nanjappa judgment, my lord, may kindly see, it was passed by, my lord, two judges, my lord. And, my lord, the date of delivery of that judgment is, my lord, February 13, 2004, my lord. And Swaran Singh was on 5th January 2004. And this was, my lord, February 13, 2004, my lord. And in this Nanjappan judgment, my lord, that Swaran Singh was not discussed, my lord. Swaran Singh was not at all, my lord, considered. Because, my lord, in the chronological list of cases cited of that Nanjappa case, my lord, Lordship will find there is no discussion of that Swaran Singh judgment.
So what is your submission?
So, my lord, my submission is that, my lord, in regard to that, my lord, pay and recovery, the dictum of that, my lord, Swaran Singh judgment, that will follow, my lord.
And Nanjapan is not binding.
Nanjapan is not, my lord, because, my lord, it was Nanjappa was passed by, my lord, 2 judge bench.
Okay.
Swaran Singh was passed by 3 judges bench. And, my lord, that Swaran Singh judge one prior to that Nanjappa. And while passing that Nanjappan judgment, my lord, Swaran Singh was not discussed. So, and my lord, may kindly come to take up my written submissions, my lord.
Yes.
My lord, there, my lord, I have in a categorical manner, I have said, my lord, why, how they have failed to prove, my lord, their burden, discharge their burden. My lord, ground number 1, my lord, under the heading 1, my lord, that erroneous finding in paragraph 28 of the impugned judgment, my lord. It is most respectfully submitted that the finding recorded by the learned tribunal in paragraph 28 of the impugned judgment to the effect that driver of the offending vehicle did not possess a valid and effective.
Which page you are reading?
My lord, the first page of my written argument, my lord.
Okay. Yes.
Yes. My lord, first, my lord, point number 1, my lord. It is most respectfully submitted that the finding recorded by the learned tribunal.
I'll go through it.
Yes.
I'll go through it.
Yes.
You have submitted.
I'll give some reply, Lordship.
Yes. Anything
Yes.
else?
Yes, my lord, I have. My lord, there.
Your written argument, I will go through it.
Yes. Then, my lord.
Yes.
What he is submitting, Lordship, that the tribunal's finding that pay and recovery is wrong. If I'm
No,
correct
he's,
on
no,
that.
he's not wrong.
He's saying that. That is what he says,
No, no.
isn't it?
No, my lord, 2 things, my lord. My lord, my lord, I am on 2 footings, my lord. My lord, I am here, my lord, in this written argument, my lord, I am trying to show that he has failed to discharge that burden, that is, my lord, one aspect, my lord.
Mentioned in clause 3 of the guidelines of Swaran Singh.
Yes, my lord, that findings, my lord, not only 3, my lord, from reading of that 1 to 11, right, my lord, that, my lord, that burden which is cast upon them, my lord, because they have failed to prove, my lord. Though they have, my lord,
Shown that the
yes,
license was.
yes, but how they have failed, my lord, I have clearly mentioned.
In this case, what has happened to license? Is it fake or
He doesn't
renewed? Doesn't have license at all.
Since new grounds are taken, Lordship, I am giving some new judgments.
No,
now.
my lord,
Because what he is submitting, he has filed a cross objection. In that also, he has not mentioned that the tribunal is wrong in coming to that, that the license was not there. In argument,
Okay.
in
your cross objection, you have not challenged.
no,
but I'm giving some judgments on that.
but my lord, I am not saying that I am only hammering on this one. My lord, my argument is on 2 folds, my lord. First one is, my lord, that, my lord, they have failed to discharge their, my lord, burden. That is one. And second one is, my lord, for a moment, if I presume that they have able to prove their defense, in that even also, my lord, that's because I am a, my lord, third party, my lord. So this is my respectful submission, my lord. So I am entitled to get the money, and they may go for recovery from the owner, my lord. There is no bar as such. That is my respectful submission.
Yes.
Lordship. About that, Lordship, I'm coming to Papu, who is supposed to prove, Lordship. This is also 3 judges bench. And Papu,
What it says.
that it is the owner who has to prove that he had a valid driving license. He has not only to give a written statement, use evidence, and then prove. Then only the owners will fall on the insurance company. Because now a new argument is being made that we have failed to prove. As per Swaran Singh, but as per Swaran Singh, we have proof that he does not have a valid driving license, and had it been a driver and a owner, it would have been a different scenario. Here, Lordship, he is himself the owner and driver. I'm submitting this Pappu judgment, Lordship. Relevant paragraph 11.
Pappu and Vinod Kumar.
You've
And
given that.
Malad, Pappu and Vinod Kumar Lamba, Malad, that judgment I have placed, Malad. Malad, that is
Okay.
also three judge bench, Malad. That also says, Malad, even it's, Malad, where driver did not possess a valid driving license, even in such circumstances, Supreme Court in paragraph 19 of that judgment held that insurer cannot avoid its application
But who
towards
has
the
to
claimant
prove?
and directed pay and recover.
No, but who has to prove? That is not mentioned
No,
in that
No,
judgment.
that is why, Malad, I am very
So,
clearly, I am submitting.
Lordship,
I am very clearly submitting, Malad. I am on 2 points, Malad. First, I am showing that he has failed to discharge the burden. And on the other hand, I am also, my lord, my submission is that suppose, my lord, they are able to prove that the defenses, my lord, and prove that my lord, to prove their stand regarding violation of policy condition. In that even also, my lord, Swaran Singh, that my lord, Pappu and Vinod Kumar, that Samanna judgment, then my lord, Rani and National Insurance, my lord, this all says, my lord, that, my lord, as because victim, that is a third party, my lord, so the insurance company is
if
directed
you
to
finish,
pay.
I'll continue.
And
That is Pappu Lordship. I'm submitting that it is the owner, but we not only one DW, we have even called the DTO office. So we prove. Lordship, I'm giving this MSC appeal to 92 Lordship, where this honorable court held that when there was no driving license, no liability. It was the owner who was directed to give the. Then, Lordship, on the count of income, Lordship, I'm submitting this Rani and others judgment, Lordship, about when the income is not proved. Here it was taken for a skilled worker, it was taken as rupees 5,000, Lordship. That will be relevant paragraph 14, Lordship.
So if it is 5,000,
The compensation will be
in this case, it has been
6,000.
6,000. 5,000 was on what basis?
Still, because he was skilled worker,
What was the basis?
yes.
Mr. Datto, your argument regarding that failure of the insurance company to prove
yes,
breach of policy condition may not be very strong arguments, because in this case the owner himself is the driver, so the care,
that is there. That is
therefore if he himself is not having driving license, okay, anything else?
History judgment and something.
You mark it paragraph number.
Paragraph I have marked. The paragraph I have marked. In Rani judgment, Lordship, paragraph 14.
Third, Miss Adi Majumdar, learned counsel for the appellant. Stop. Also heard Mr. M. Datta, learned counsel for. You have marked the paragraphs.
Yes, Lord. These were earlier also given. I'll again check.
And the top of the
Or
judgment.
top.
Also heard Mr. M. Datta, learned counsel for respondent. Respondent number?
11214.
Respondent number. Respondent/claimants, as well as cross objector. So, by this common judgment, this court proposes to dispose of the instant MAC appeal that is MAC appeal number 172/2021, filed by the insurance company, as well as the cross objection number 17/2022, filed by the claimants. The insurance company has filed this the instant appeal, impugning the judgment and award dated 17/3/2021, passed by the Motor Accident Claims Tribunal, Golaghat, in MEC case number 41/2015, whereby the the appellant insurance company was directed to pay a compensation amount of rupees 10,37,482 to the claimant, along with an interest at the rate of 6% per annum, and thereafter realize the same from the owner of the offending vehicle. Whereas the cross objection has been filed by the claimants, respondents, praying for enhancement of the compensation awarded to the claimants on compensation awarded to the claimants. Stop. The facts relevant for adjudication of the present appeal, as well as the cross objection, in brief, are that the father of the husband of the original claimant has expired.
Yeah, expired.
Husband of the original claimant, namely original claimant within bracket Srimati Makon Hajorika, bracket close, namely late Hemo Hajorika, was returning from Rangamati Mandir on 7/3/2015 at about 12 noon, along with on the National Highway number 37, by pulling a hand cart. Stop. At that time, one motorcycle bearing registration number AS02/L 04393, being driven in a rash and negligent manner, knocked him with a great force. Stop. As a result of the said accident, the husband of the original claimant sustained injuries on his person, and he was stopped. Thereafter, he was immediately shifted to Dhemaji CHC in a serious condition. He was later on referred to the Jorhat Medical College and Hospital, And from there, he was again referred to the Gauhati Medical College and Hospital. However, ultimately during treatment, on 2/4/2015, the said Hemo Hajarika succumbed to his injuries. Stop. Thereafter, the wife of the deceased, namely Srimati Makun Hajarika, approached the Motor Accident Claims Tribunal Golaghat by filing an application under Section 166 of the Motor Vehicles Act, claiming compensation for death of her husband in the aforementioned motor vehicular accident. The said claim case was registered as MEC case number 41/2015. So it is pertinent to mention herein that at the time of his death, the deceased Hemo Hajarika left behind his wife Clement and two daughters and two sons. Stop. It is also pertinent to mention herein that after the accident, an FIR was lodged in respect of the said accident before the Dargaon police station, and a case, that is Dargaon PS case number 56/2015, was registered under section 279/338/304A of the Indian Penal Code against the rider of the motorcycle bearing the rider of the offending motorcycle. Stop. The claim case was contested by the owner, contested by the owner of the offending motorcycle by filing a written statement. The present appellant also contested the claim case by filing a written statement wherein it took usual defense which are normally taken by insurance company in claim cases. Upon pleadings of both the parties, following issues were framed by the Motor Accident Claims Tribunal. Court issues from page 13 and 14A marked as A. The claimant examined Srimati Makoni Hajarika within bracket since deceased bracket close, in support of her claim, adduced the evidence of two witnesses, including herself as CW1 and one Khalil Ali as CW2, and exhibited as many as 9 documentary evidence. Stop. The owner of the offending vehicle did not adduce any evidence whereas the insurance company, that is the present appellant, adduced evidence of 3 witnesses in defense, namely Shri Pradeep Kumar Singh within bracket as DW1, Shri Sudipta Thakur as DW2, and Shri Arup Jyoti Boda as DW3. Ultimately, by the judgment and award dated 17/3/2021, which has been impugned in the instant appeal, the tribunal held that the claimant is entitled to get a compensation amount of rupees 10,37,482 along with 6% per annum. However, it also came to a conclusion that there was breach of policy condition on the part of the owner of the offending vehicle, and as such, though the insurance company was directed to pay the aforesaid amount to the claimant at first, thereafter a liberty was granted to the insurance company to realize the entire amount from the owner of the offending vehicle. Stop. Miss R.D. Majumdar, the learned counsel for the appellant insurance company, has submitted that since the insurance company had been able to prove its defense of breach of policy condition, as the driver of the offending vehicle was not having any driving license, the tribunal has erred in directing the insurance company to first pay the compensation amount to the claimant and thereafter recover the same. She submits that when the breach of policy condition has been clearly established by the insurance company, it is not liable to indemnify the owner in case of any liability to pay compensation to the claimant by the owner. She also submits that alternatively, even if the insurance company is required to pay the compensation first to the claimant and thereafter recover the same from the owner, some directions are necessary as regards mode of recovery, as clarified by the Apex Court in the case of Nanjappan versus, in the case of
Company.
Oriental Insurance Company Limited versus Nanjappan and others.
2004.
reported in 2004-13 SCC 224. She submits that she submits that the insurance company has already deposited 75% of the awarded amount before the registry of this court.
Lordship, one more thing I am submitting because Swan Singh, Lordship, in Swan Singh, it is mentioned if the insurer does not pay within 30 days of passing of the judgment, the tribunal has to start the process. That is mentioned. He read also that part also. So that is not done because we filed in 2021 9. Within 1 month, the insurer has to pay, deposit the amount.
Insurer or insured?
No, insurer. Insured, yes, insured. Yes. Insurer, we are insurer.
You are insured.
Insured,
Insured.
insured. Because Swan Singh, it is mentioned 30, he read that part.
Kalika. And if it is required to deposit remaining amount in terms of the direction of the Motor Accident Claims Tribunal, same should not be released immediately to the claimants. She submits that in terms of the directions of the apex court in the case of Nanjappan, in the case of Oriental Insurance Company Limited versus Nanjappan and others Supra, before release of the amount to the claimants, owner of the vehicle shall be issued a notice and he shall be required to furnish security for the entire amount which the insurer will pay to which the insurance company will pay to the claimants. Only this much.
I have my written argument also.
Yes.
I mentioned in our High Court past judgment where there was no driving license, the insurance company was not made liable. That I have judgment, I have submitted to Sikandar Ali.
She also, next para, learned counsel for the appellant also submits that the tribunal also erred in assessing the income of the deceased and at ₹6,000 per month without there being any evidence as to that effect on record. She submits that though the tribunal has correctly not relied upon Exhibit 7 exhibited by the claimants, however, thereafter, without any proof of income, it assessed the annual monthly income of the deceased at ₹6,000 per month, merely on the basis that the deceased was an able-bodied person when he died. She submits that under such circumstances, the notional income of an unskilled person, that is, you will give some judgment, notional income.
Given Rani judgment of 5,000.
At 5,000.
Can consider. I've given
Because you have submitted notional income sum at ₹3,000.
but minimum wages, Lordship. minimum wages, so 5,000, the judgment I have given is not of 3,000, it's of 5,000. Rani's judgment is 5,000 for,
That is rupees 3,000 should be taken as income of the deceased. She, however, submits that a coordinate bench of this court, in the case of
that is apex court judgment.
no,
Rani judgment is apex court judgment.
5,000.
Yes, apex court judgment.
She, however, submits that. Then you are not going. Your 3,000 is not your submission.
So that is my ground of appeal, Lordship, but since apex court has given some judgment, I am presenting it fairly, Lordship.
3,000. However, she fairly submits that under similar circumstances, the apex court in the case of Rani and others versus National Insurance Company Limited and others reported in 2018 S8 SCC 492 has assessed the notional income of the deceased at rupees 5,000 per month.
Last page, Lordship.
Rupees 5,000 per month. Stop. She submits that she submits that the income of the deceased may be similarly assessed in this case also. She also submits that the Motor Accident Claims Tribunal also erred in not clarifying in the impugned judgment that the insurance company is not liable to pay any interest on the amount which is assessed, which was added to the income of the deceased on account of future prospects. She submits that as the which judgment you are relying?
These three judgments, Khushbu Chirania, alias Kanta Chirania versus Kamal Kumar Savarasti. There I have not given those copies, Lordship. If Lordship needs, I can give them.
If for a minute, the judgment, these courts, you can take it back.
Yes, Lordship, because I have to submit it.
No, you can take it back. She submits that before that. She submits that as the amount assessed against future prospect was not accrued, was relatable to be an income to be received in future, and as such there could not be any loss to the claimant for payment of future prospect at the time of death of at the time when the deceased met with an accident. Hence, no interest may be awarded against such a amount assessed on the basis of future prospects. In support of her submission, she has cited following rulings. Khushbu Chirania versus Khushbu Chirania alias Kanta Chirania versus Kamal Kumar Sovasaria, reported in 2018, 0 Supreme, Gauhati 966. Nasima Begum versus Keramat Ali, 2019, 0 Supreme, GAU 507. Oriental Insurance Company Limited versus Champavati Day and others. Judgment dated 1/10/2019 in MAC Appeal 378. Anything else from your side?
I've given Pappu judgment because he made an argument. If that argument is not written, then Pappu is judged.
He has also cited judgment of the in support of her submissions. Learned counsel for the appellant has also cited judgment of the which court it is, Apex Court, in the case of Pappu and others versus Vinod Kumar Lamba and another, within bracket, judgment dated 19 January 2018 in civil appeal number 20962/2017. On the other hand, learned Mr. M. Datta, learned counsel for the claimants has submitted that
My lord, I have formulated my submissions, my lord, in a short manner.
submitted that the tribunal has erred in holding that there was a breach of policy condition. He submits that tribunal has erred in holding that it was the owner of the offending vehicle who is liable to pay the compensation, who is ultimately liable to pay the compensation to the claimants. He submits that the mere absence of driving license of the driver at the relevant time is in itself not a defense which is available to the insurance company under section 149 of the Motor Vehicle Act. He submits that as held by the Apex Court in the case of National Insurance Company Limited versus Swaran Singh, reported in 2004, 3 SCC 297. To avoid its liability towards the insured, the insurance company has to prove that the insured was guilty of negligence and has failed to exercise reasonable care in the matter of fulfilling the condition of policy regarding use of vehicle by duly licensed driver or one who is not disqualified to drive at the relevant point of time. He submits that this fact could not be proved by the insurance company by adducing the evidence of DW1, DW2, DW3. ইয়াত এটা বস্তু লিখি ৰাখক ওপৰত লৈ যাব. Learned Counsel for the appellant has submitted that since in this case the owner of the offending vehicle was himself the driver and he was not possessing the driving license. Hence, the insurance company has
He knowingly violated the
and
policy.
he knowingly violated the
The condition.
policy condition. The insurance company has duly proved that the insured was guilty of negligence and failed to exercise reasonable care in the matter of fulfilling the condition of policy regarding the use of vehicle by a duly licensed driver.
For that, Lordship,
Stop.
I have given MSc appeal number 292, Lordship, National Insurance.
It is there in Swaran Singh.
Swan Singh, no, that because of that breach, insurance company is not liable. Our High Court has.
She has relied, eto uporot lo jabo, huh? She has, in support of her submissions, she has relied on the ruling of a coordinate bench of this court. In the case of
National Insurance Company versus Muhammad Iqbal Hussain.
National Insurance Company Limited versus Muhammad Iqbal Hussain, alias Iqbal Hussain and others, within bracket judgment dated 4/4/2022 in MAC appeal number 292/2018. Now again from respondent. Learned Counsel for the respondent/cross-objector has further submitted that even if this court comes to a conclusion that there was comes to an agreement with the finding of the tribunal that there was a breach of policy condition by the owner of the offending vehicle. Still, the tribunal was not wrong in directing the insurance company to first pay the compensation to the insured, to the claimant, and thereafter recover the same from the owner as same has been as the said right of the tribunal has been held, as it has been held in the case of Saran Singh, that tribunal does have right to direct, pay and recover in case of a breach of policy condition by the owner. Regarding future prospect, do you have any submission?
Yes, yes, ma'am. My lord, I have placed one judgment of my lord honorable apex court, my lord, that Oriental Insurance Company Limited versus Nehru.
What it says?
It says, my lord, paragraph 11.
What it
It
says?
says, well, in fact, it is due to the reputation or refusal to consider the claim that the claimants are driven to the, when the matter is pending before the tribunal or in appeal before the higher forum, the claimants are deprived of the compensation for future prospect. If they are paid in time, it could be utilized by the claimants, and on failure, the loss of dependency would force claimants to source of their livelihood from elsewhere. My lord, here, my lord, consider interest was granted on future prospect.
Where is that para?
My lord, paragraph 11, my lord. Paragraph 10, 11, 8, 10, and 11. My lord.
He also submits that the contention regarding of learned counsel for the appellant that no interest may be awarded on future prospect is also not tenable in law in view of the judgment of the apex court in the case of Oriental Insurance Company Limited versus Neuro and others, reported in Manu/SC/0894/2025. He also submits that the tribunal has also erred in assessing the annual income of the, in assessing the monthly income of the deceased at only rupees 6,000. He submits that though the tribunal did not rely on Exhibit 7, however, Exhibit 8, which is the certificate issued by whom?
Certificate was, that was issued by the
Issued by Dash, clearly shows that he that the deceased was a fish farmer and
dealing with the business of
and
fishing.
dealing with the business of fish farming, and it is also in evidence that he had to maintain a family of 6 dependents, and therefore the evidence of CW1 that her husband used to earn an amount of rupees 10,000 per month should have been taken into consideration, and the income of the deceased ought to have been assessed at rupees 10,000 per month. He also submits that the interest awarded interest awarded on the amount of compensation assessed by the tribunal at 6% is also on the lower side. He submits that there are rulings of the apex court wherein the apex court has granted interest at the rate of 9% on the awarded amount, and same was held to be reasonable and justified. He therefore submits that the interest on the awarded amount should be enhanced to 9% per annum at the per annum stop. He further submits that the tribunal also erred in not granting any compensation against the head of parental consortium at the. He submits that since the deceased was survived by 5 children, how many children?
4 children.
4 children. They are entitled to get parental consortium at the rate of rupees 44,000 per head, in addition to grant of spousal consortium to the
Wife of the deceased.
wife of the deceased. Anything else?
Lordship, Exhibit 8 was issued by my lord, National Federation of Fishermen's Cooperative Limited, New Delhi.
That is a training certificate, Lordship, not a.
No,
That he underwent a training,
my lord, that shows, my lord, that the deceased was, my lord,
Issued by whom?
issued by, my lord, the National Federation
Issued by Gauhati Likibo, National Federation of
Fishermen's
Fishermen's
Cooperative Limited,
Cooperative Limited,
New Delhi.
New Delhi. Stop. He accordingly submits that the compensation awarded to the claimant may be enhanced and the cross objection may be allowed. I have considered, no, he has cited in support of his submission. Where are your rulings?
My lord, along with that, my lord, written submissions, my lord. Tell my lord. Total 15 judgment I have.
In support of his submission, learned counsel for the claimant / cross objector has cited following rulings. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record, including the records of the MSC case received, which was requisitioned in connection with this case. I have also gone through the rulings cited by learned counsel for both sides in support of their respective submissions. Stop. Reserved, judgment reserved.
Deeply obliged.
Next item.
Item 10.
A citation belongs separate file of document.
That judgment, can I take that?
Yes.
The one document.
Yes, you can take it back. judgment to return দিব তেওঁ যিটো বিচাৰে Yes, Ms. Goswami.
Lordship, kindly pass over the matter for time being. My senior is in court number 5, making his submission.
See, may be taken up at two, Lordship. Part heard matter,
Part heard.
Lordship. At two.
In second half, we'll take it up.
Lordship. Authorized, Lordship.
Next item.
So here in this case, Lordship, Mr. R.C. Pal, appearing for the respondent.
This we have heard.
Yes, he was supposed to file written argument. Till date, he hasn't been filed.
Second half will be taken.
No, we'll reserve the judgment because we have already heard.
Judgment ready.
You have also submitted any written.
No, I have not submitted. My memo appeal is sufficient, Lordship. That explains everything. On the other day,
Mr. Paul will be coming.
Yes, Lordship.
Okay, let him submit written. We'll reserve the judgment.
Lordship, I have a matter in court number 13. Lordship will kindly accommodate me.
Okay. Heard Ms. P. Bhomik, learned counsel for the appellants. Also heard Mr. M. Talukdar, submitting on behalf of Mr. R.C. Paul, who submits that Mr. R.C. Paul is on legs in a different court and he would be submitting his written arguments during the course of the day. Considering the submissions made by learned counsels, the judgment in this case is reserved.
Lordship, I would like to say only one thing. The other day, Mr. Paul has submitted copies of
This is regarding contributory
Not
negligence.
two judgments of this honorable court, but those judgments doesn't help him in any manner. Lordship will kindly look into that because here in one of the judgments cited by Mr. Paul, the appeal was filed by the insurance company and the award has been upheld. This honorable court has not interfered. And in the second one, relied by Mr. Paul, the awarded amount has been apportioned between two insurance companies because the offending vehicle was charge sheeted by the police and the insurer of that vehicle was not impleaded. So therefore, this honorable court has apportioned. Here in our case, the offending vehicle has been charge sheeted by the police and we have impleaded only that vehicle.
Figo. Ford Figo.
Because,
Okay.
no, offending vehicle is
Indica.
Tata Indica. The accident has occurred on Ford Figo.
Okay.
So these judgments are not applicable in this case. Your Honor. The Honor will kindly look into it.
Wait for the judgment.
I will. Right. Item 12.
Ramesh, itu reserve হয়েছে চেম্বারের দিকে। Yes, item number
12.
Pathal.
Yes, my lord. It's the 50 foot shade case, my lord, if lordship may recall.
Which
Terminal charge matter. My
is for the other side.
Miss B. Devi, my lord, repeatedly sought time seeking instruction since 6 months, only in respect to one issue.
You inform her.
I'll inform, my lord. I'll inform. Can it be taken up after lunch?
Okay,
I'm grateful.
we'll take it up.
Much obliged. Item 13.
Where is Miss Gan? On that day, she has completed her submission.
But
My side may be hard, Your Lordship.
You may.
Now, Your Lordship, this is a matter which arises out of a dismissal of a petition under Section 5 of the Limitation Act
Okay.
by the district judge Sonitpur. This is basically
Limitation Act.
Limitation Act.
For filing a petition under 37.
Lordship, petition is the objection they have to file, Your Lordship, within 30 days under Article 119B of the Limitation Act. But it was much beyond. The matter went up to the Supreme Court, Your Lordship, and the Supreme Court holds that the district judge which dismissed the petition of the present respondent that it is beyond time, and upholding that order, Your Lordship, the High Court passed order and both the orders, Your Lordship, were set aside by the Supreme Court, and whatever points actually this respondent raised, that the objection.
I am not getting anything.
Lordship, whatever, Lordship, I take Your Lordship to the judgment, Your Lordship.
No, you refresh the memory.
Correct, Your Lordship. Page 71, Your Lordship will come.
Yes.
That 68, relevant portion is 68, Your Lordship.
Yes.
68, Your Lordship. 3, paragraph 3, Your Lordship, regarding facts. This is the judgment rendered by the Supreme Court, Your Lordship, on 3/1/2025. Facts. The appellant's husband, appellant means, Your Lordship, this respondent, Your Lordship, was the sole proprietor of a firm, Messrs. SR Engineering Construction, which had secured a work order bearing number so in the year 1987-88. So work order, Your Lordship, that is the contract, Your Lordship, relates back to 1987-88 from the respondent, that is the Union of India. The work order was governed by the general conditions of contract, of which clause 70 contained the arbitration clause. The agreement involved a firm constructing a permanent armament section at Tezpur. The firm completed the work. That is, the respondent completed the work and raised a bill for this same on 18/1/1993. However, as the respondent did not make the payment, the appellant was, that means the present respondent, Your Lordship, compelled to request for arbitration to resolve the dispute. The respondents declined, that means the appellant, present appellant, and thus the appellant filed an application before the Delhi High Court seeking the appointment of an arbitrator, which was dismissed due to lack of jurisdiction. Another application by the appellant before the Additional District Judge Delhi made the same fate and was only on 26/8/2019 that the appellant's application under Section 20 was allowed and an arbitrator was appointed by the District Judge Sonitpur by an order entitled Suit Arbitration, case number 19/2003. The appellant's husband passed away during the course of the arbitral proceeding, and she came to represent him as his legal heir. 4. Finally, the arbitrator heard the parties and made an award on 31/5/2022, in favor of the appellant, that is the respondent here, and directing the respondent to pay a sum of rupees 1,33,47,268.92 with an interest at the rate of 9% per annum till realization. Para 5. Despite proceedings culminating in an award, it could not be published as the respondents
The arbitrator's fees was not paid.
achieved
Because arbitrator's fees was not paid.
not paid, Your Lord. Correct,
Okay.
Your Lord. Because his
Mm.
share, that is the Union of India, each share was not paid, Your Lordship. This para will clear it. Despite proceedings culminating in an award, it could not be published as the respondent had not cleared its dues towards the arbitrator's fees. The appellant felt compelled to file an application. Appellant means this respondent before the district judge. Sonitpur under section 38 of the 1940 Act, seeking a direction to the respondent to clear its dues of the arbitration fees. Your Lordship, there is a provision under section 38. If the other side does not pay, Your Lordship, the arbitrator's fees, Your Lordship, the arbitrator may not publish and may not give the copy of the award, Your Lordship, to the other side, and the party who clears the dues, Your Lordship, it will be only provided to them. Here in this case, the Union of India, the richest entity in India, Your Lordship, Union of India is the richest entity, Your Lordship, and they failed to pay this share to the arbitrator, small sum, Your Lordship, to the tune of thousands. And because of that, Your Lordship, the award could not be published by the arbitrator. And this way, that Your Lordship, they delayed the matter like a contract of the year 1987-88, Your Lordship. Till date, Your Lordship, it is lingering, Your Lordship. You see the sequence of the facts. Seeking a direction to the respondent to clear each part of the arbiter, the district judge Sonitpur passed an order on 21/9/2022 directing the respondent to clear the state dues of rupees 47,212.33. The order further stated that upon clearance of the dues, a copy of the award shall be furnished to both the parties. 7. It is an admitted fact that the appellant received a copy of the award on 22/9/2022. That is the respondent, Your Lordship. We paid, that's why we were given. Notably, the respondent had neither cleared the balance share of the arbitrate fees nor they did collect the award by the above mentioned date. Above mentioned date means 21/9/2022. In fact, they deposited a check towards the balance payment for the fees only on 18/11/22, after which it received the notice of filing the award on the same day. So on 18/11/2022, Your Lordship, they paid the amount, Your Lordship, that is the share of the arbitrator's fee, Your Lordship, and on that day they were furnished. And that day is the point, Your Lordship, according to them, Your Lordship, that it is the point of knowledge. That is the point of notice also, Your Lordship.
Which one? 18?
This 18/11/22, Your Lordship, according to them, Your Lordship. So on the other hand, Your Lordship, we raised the objection as regards this 18/11/22. We raised the point before the trial court by filing a petition under section 17, Your Lordship, of the old Arbitration Act 1940, that the limitation runs from 21/9/22 because that was the date by which the trial court, Your Lordship, that is the district judge, directed the Union of India, your lordship, that is the appellant here,
To deposit the dues.
to make the payment and get the copy of the award, and that it has been filed before the court. So Supreme Court has held that order dated 21/9/2022 is the date of awareness that amounts to notice. That amounts to notice, your lordship, and the limitation runs from that day onward, that is 21/9/2022, and the limitation as prescribed under Article 119B, your lordship, it is 30 days. So according to Supreme Court, your lordship, that the period of objection against the award, your lordship, which has been filed before the court on payment by the Union of India, so it runs from 21/9/2022 and it expires on 29/2010/2022. And beyond, your lordship, it is marked by limitation. And that has been held by the court, Honorable Supreme Court, your lordship, and in favor of the present respondent. In favor of the present respondent. But in the Supreme Court, your lordship, it was known to them that it is an objection against the award which has been submitted before the court, your lordship, to make it rule of the court. That is called, your lordship, in legal language, rule of the court. So to make it rule of the court, your lordship, which has been, the award has been filed before the court. So that is there since the date 21/9/22, because on that day, the award is before the court only for non-payment of the share of the arbitrator. It was not published, nor any copy was given to the present appellant.
We will continue at 2. At 2 we'll continue.
Your lordship, at 2, your lordship, I have another matter, your lordship, first item in court 10, your lordship. It will take only 5 or 10 minutes, your lordship. Therefore,
Here or there?
Here, your lordship.
5 minutes you will take here or?
No,
court?
there, your lordship.
There,
That
okay.
is just like order, your lordship.
Okay.
So after
Then
that,
after you come, we'll take it up.
your lordship.
May I please, lordship?
But
Yes.
10 minutes, it may be, for the time being, your lordship, it may be
No, we'll take it up after you come.
lordship.
Item number 11.
Maybe take-
Today is fixed for to submit the detailed argument.
You'll be submitting.
No. So my lord, so I prepared, but I could not complete it. But this lordship has already reserved the judgment.
You submit it within a day or two.
My lord,
Within a
with
week.
the,
Within a week.
next Monday, I'll submit.
Okay, next Monday you submit to the court.
Delivery of judgment. Item number 33.
For reasons mentioned in the judgment, this appeal is allowed.
Item number 32.
amount or-
35.
You go through the judgment, it will be uploaded. 34 and 35. Insurance company's appeal is dismissed. Claimant's appeal is allowed.
36 and 37.
FAO and CRPIO both are dismissed.
Dialing item number 38.
Yes, Mr. Goswami, you
Let's
had to produce some judgment.
Lordship, what happened that year was raised.
30.
30. Was raised that that deposit has not been made. My submission was that the honorable.
There is a judgment.
That it has done on the basis of a judgment, that's what I'm saying.
Where is that?
That this is the judgment lordship may say, on the basis of this judgment lordship. There are two judgments on the same lordship. Under judgment by, because this was an interim order. The claimant went to Lordship Harris, Supreme Court also.
This is Apex Court's judgment.
No, this is the what High Court said. High Court, the issue was there that there no deposit was made, Lordship may say para 44, and therefore appeal is not maintainable. That was the issue before the High Court.
What High Court held?
I said, it admitted the appeal that this is not the appeal can be filed even without deposit. Lordship may say para 44.
You have a copy of the judgment?
No, I'm not talking about it. I'm going to go to High Court's
No, you have a copy with you.
this one.
Read 44.
Para 44. A strenuous argument is made to the effect that these appeals are not maintainable on account of the omission of the insurer to furnish the certificate from the commissioner, Spokesman Company, in terms of the third proviso to section 30. Mr. Sekhar, the learned counsel appearing for the respondents, places reliance on a decision of this court rendered in Oriental Insurance Company versus Ronald Chandra Das. I have carefully considered the decision so relied upon, but what I notice is that this court, while dealing with the contention raised on behalf of the workmen, that the appeal is to be maintainable on the ground that the compensation has not been deposited by the appellant, that is insurance company, as provided in section 30 of the WC Act. Observe that it finds definite force in the submission. A court may find force in the submission made on behalf of a party. Having force in the submission made by the learned counsel cannot be stretched to mean that the court has expressed its definite decision on the point raised is correct. The decision is binding for what it decides and not what can be deduced from it. No clear decision has been given in Anil Chandra Das that an appeal under section 30 will not be feasible by an insurer without the insurer having deposited the amount of compensation in terms of the third proviso to section 30. Thus, neither this decision lays down nor any other decision of this court has been brought to the notice of this court to show that this court has held that the third proviso to section 30 is mandatory for preparing an appeal even by the insurer. Every word used in the statute has to be given its the meaning, and which is general and universal in nature. If the word employer as occurring in the proviso in question is interpreted to mean and include insurer, then this interpretation has to remain applicable in all eventualities, meaning there.
No. What happened to that issue?
To that issue, Lordship, 48, Lordship. Because of what has been discussed and pointed out.
No. This is on a different line. But this judgment does not say whether the deposit is necessary or not.
Appeal was admitted here.
But it has also remained silent.
Lordship,
Whether it is.
Lordship, if I may read out, Lordship.
Yes.
Para 47, there is, if I may emphasize, no ambiguity in the wording of the third proviso and or in the definition of employer, and it is only the employer. If he prefers an appeal under clause A, who has to deposit the amount awarded, it is very different.
When read
Para
again.
47, Lordship.
Yes, read again.
There is, if I may emphasize.
Which line you are?
Para 47.
Para 47, every word used in the statute.
I think.
That is the first line. Para 47.
Para 47. Lordship may ask me to come to the main part, so I will have to read in that case the entire 45, 46. I'll come to the conclusion.
Okay, what para 47 says?
There is, if I may emphasize, no ambiguity in the wording of the third proviso and or in the definition of employer, and it is only the employer, if he prefers, is only
the employer, if he prefers an appeal under clause A, who has to deposit the amount awarded. Otherwise, no appeal would lie. The proviso admits of no entities other than the employer. There's a difference between employer and insurer also.
Okay, okay.
Because of what has been discussed above and pointed out above, I have no hesitation in holding.
Okay,
that the-
this court held that if the appeal is by employer under 30, only then it is required. But you are insurance company.
Ever
So
since
this matter is,
the High Court has, I have gone through it, my lord. I have,
no,
my lord,
this matter has been settled then.
settlement. Because my lord, D.
Then we'll admit the appeal.
Yes, please.
Where is the substantial question? Heard Mr. R. Goswami.
Page.
Substantial question.
Page 8 of my memo.
What is the substantial?
For that, in the given facts, where the claimant did not prove the jurisdictional facts like the injury arising out of an in course of employment, does the learned commissioner for employees compensation have the jurisdiction? Because that is a jurisdictional fact, whether that injury has arisen out of the and in course of employment.
Okay, one is enough. What is two?
Two is that for that in the given facts, when the claimant did not prove the involvement of the insured vehicle, which is a jurisdictional fact. One is arising out of.
That is question of fact.
This is also again, Lord say, it's a question of fact that has to be proved with some, which is a jurisdictional fact by producing one single police report like FIR GD. There's nothing, Lordship. How is the involvement of vehicle? One first was relating to whether it's arising out of employment.
Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. M. Datta, learned counsel for the respondent. This appeal under Section 30 of the Employees Compensation Act 1923 has been preferred by SBI General Insurance Company Limited, impugning the judgment and award dated 24/3/2025 passed by the learned commissioner, employees compensation, Golaghat in EC case number 5/2024. Stop. On the last date, that is on 11/5/2026, Mr. M. Datta, learned counsel for the respondent, raised an objection as regards maintainability of the instant appeal in view of the third proviso under Section 30 of the Employees Compensation Act 1923, which requires that no appeal shall lie unless memorandum of appeal is accompanied by a certificate by commissioner to the effect that appellant has deposited the amount payable under the order against which appeal has been preferred. Mr. R. Goswami, learned counsel for the appellant, submits that no such necessity of depositing the amount awarded is there under Section 30 if the appeal is preferred by an insurance company. He submits that this matter has been laid to rest by a coordinate bench of this court in the case of Oriental Insurance Company Limited versus Umesh Nath, reported in 2004 Supplementary GLT 158. He submits that in the said case, it was observed by the coordinate bench of this court that the third proviso is the necessity of depositing the awarded amount under third proviso to section 30 of the Employees Compensation Act 1923 is applicable only if the appeal is preferred by the employer within inverted comma. However, since the present appeal is not by the employer but by the insurance company, hence the said proviso is not applicable to this appeal. This court is, as the matter has already been settled by the coordinate bench of this court in the aforesaid judgment, it is binding on this court unless this court takes a contrary view. However, this court is in agreement with the aforesaid view. Hence, the objection regarding maintainability raised by learned counsel for the respondent is not sustainable. Stop. After considering the submissions made by learned counsel for the appellant, following substantial question of law is formulated in this appeal. Whether in view of the failure of the claimant to prove the fact that the injury sustained, who suffered injury?
All of the employee of the this.
The claimant himself.
No. Claimant is the claimant's husband.
Sustained by the husband of the claimant arose out of the course of employment. Reread it. Arose out of course of employment. The learned commissioner, employees' compensation, had jurisdiction to make insurer liable under the provisions of Employees' Compensation Act 1923. This one is sufficient. Let the records of EC case number 5/2024 be called for from the office of the Commissioner, Employees Compensation, Golaghat. Mr. Datta, you are appearing for all the respondents.
Respondent number 1.
1, 2, and 3.
1, 2, and 3.
4 and 5.
Well, 4 and 5, I'm not appearing.
Okay. Let the notice be issued to respondent number 4 and 5 also. The appellant shall take steps for issuance of notice upon respondent number 4 and 5 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 22nd July.
This is the delivered lordship to 4 and 5.
When?
To 4 and 5. Is the R1 in the Laudiment at 18/11/25.
In the delay.
In the
But here you have to take fresh steps. 22nd July.
Take that paper still.
And
Lordship may kindly record not only husband, father, because one
Husband/father
father.
in substantial question of law.
The paper still.
Stay.
Subject to release of 50%. Furnishing an indemnity bond because here I am selling you a land. I will furnish my lord.
Heard Mr. R. Goswami, learned counsel for the applicant. Also heard Mr. M. Dr. learned counsel for respondent claimant. This interlocutory application under Order 4115 of the Code of Civil Procedure has been filed by the applicant insurance company in connection with connected MFA number 39/2026, praying for stay of execution of the impugned judgment and award dated 24/3/2025, passed by the Commissioner, Employees Compensation Golaghat in EC case number 5/2024. The learned counsel for the applicant submits that applicant is ready to deposit 50% of the awarded amount as a condition for grant of stay of the impugned judgment and award. The learned counsel for the claimant is also not objecting to grant of stay on the said condition. As such, the notice to other respondents, namely respondent number 4 and 5, notices to other respondent are waived and this interlocutory application is allowed. The execution of the impugned judgment and award dated 24/3/2025 shall remain stayed during the pendency of the connected MFA number 39/2026, subject to deposit of 50% of the awarded amount by the applicant insurance company before the registry of this court within a period of 6 weeks from the date of this order. Stop. If such a deposit is made by the applicant in pursuant to this order, same shall be disbursed to the claimant/applicant by the registry after proper verification on furnishing of a bond of amount equal to the amount deposited by the insurance company. This interlocutory application is accordingly disposed of.
Obliged. Lordship, that hearing matter, my lord, one judgment I want to place, my lord, that Nanjapa, that condition is not precedent, my lord.
No, but whatever you are relying, you mark it.
Yes.
Yeah.
Have marked.
Okay.
Last. Obliged.
Yes. Parted.
item 13, continue.
itu Goswami written করে।
Your Lordship, paragraph 69, Your Lordship.
Page
Page 69, your lord.
It's yes.
Paragraph 4. Finally, the arbitrator heard the parties and made an award dated 31/5/2022 in favor of the appellant, that is the present respondent also, and directing the respondents to pay a sum of rupees 1,33,47,268.92 with an interest at the rate of 9% per annum till realization. Despite the proceedings culminating in an award, it could not be published as the respondent had not cleared its dues towards the arbitrator's fees. The appellant felt compelled to file an application before the district judge, Sonitpur, under Section 38 of the 1940 Act, seeking a direction to the respondent to clear each part of the arbitrator's fees. The district judge 6. The district judge Sonitpur passed an order dated 21/9/2022 directing the respondents to clear the said dues of rupees 47,000 such and such. The order further stated that upon the clearance of the dues, a copy of the award shall be furnished to both the parties. 7. It is an admitted fact that the appellant received the copy of the award on appellant means this respondent on 22/9/2020. Notably, the respondents had never cleared the balance share of the arbitrator's fees, nor did they collect the award by the above mentioned date. In fact, they deposited a check towards the balance payment for the fees only on 18/11/2022, after which it received the notice of filing on the same date, your lordship. Now, your lordship, this notice under section this 18/11/2022, they have taken it to be the date of notice, your lordship. On the other hand, the Supreme Court has held, no, this is not the date, but it is the date on 21/9/2022 when the learned district judge directed them to pay the balance amount, that is the balance arrears fees, onto the arbitrator, your lordship. And this way, your lordship, the entire facts has been discussed by the Supreme Court and the laws involved in the present case, your lordship. Para 8, your lordship. On 10/11/2022, the appellant
And thereafter what happened?
lordship.
Thereafter what happened?
Thereafter what happened, lordship? This responded, your lordship, file a petition before the district judge, your lordship, that as they failed to file any objection against the award, so respondent, your lordship, filed an application under section 70 that the award may be passed in terms of the award given by the arbitrator, your lordship. The award may be passed, your lordship.
Judgment may be passed.
I am placing section 17, your lordship. What does it say, your lordship?
Ramesh. 1940
1940.
Arbitration Act 1940.
Last time I have taken to
Your lordship,
the
last date, my learned.
this one.
Yes,
Furnished,
yes,
your
it
lordship.
is there. Yes,
Section 17, I am reading, your lordship. Judgment in terms of award. Where the court sees no cause to remit the award or any of the matters referred to arbitration for reconsideration or to set aside the award, the court shall, after the time for making an application to set aside the award has expired, or such application having been made after refusing to proceed to pronounce judgment according to the award, and upon the judgment so pronounced, a decree shall follow, and no appeal shall lie upon such decree except on the ground that it is in excess of or not otherwise in accordance with the award. So under section 17, your lordship, the court is to make the rule of the court, your lordship, so far as arbitration award is concerned. Now, this award, your lordship, having the other side having not furnished any objection or raised any objection before the trial court.
When this judgment was pronounced under section 17?
Lordship,
Under section 17, court has pronounced a judgment
lordship,
making the award absolute.
lordship.
When that judgment was pronounced?
That was your lordship. Later, it will be spelled out, your lordship. It was discussed by the Supreme Court that before that, your lordship, they filed the objection. Before that, your lordship, before the judgment was delivered, in pursuance to section 17, your lordship, the other side filed the objection challenging the award, your lordship. Thereafter, what happened, your lordship? The trial court found that as per the Supreme Court, the objection which has been raised by the present appellant, your lordship, before the district judge, your lordship, it was found to be barred by limitation. So at that time, your lordship, they also filed a petition as per the judgment of the Supreme Court under section 5 of the Limitation Act. So both the appeal as well as the objection as well as the
Objection under what provision?
this objection, it is under section 30, your lordship.
Section?
30, your lordship. The lordship will come into section 30, your lordship. Lordship got it.
Yes.
Ground for setting aside awards. An award shall not be set aside except on one or more of the following grounds, namely, that an arbitrator or umpire has misconducted himself or the proceedings. B, that an award has been made after the issue of an order by the court superseding the arbitration or after arbitration proceedings have become invalid under section 35C, that an award has been improperly procured or is otherwise invalid.
What is the limitation for this filing this objection?
30, your lordship.
30 days.
30 days, your lordship. Will come to Article 119B of the Limitation Act. Limitation.
Limitation. Okay.
Section 119. Under the Arbitration Act 1940, is not applicable here, your lordship. That is, your lordship, under the Arbitration Act 1940A, for filing in court of an award, that is 30 days from the date of service of the notice of the making of the award. B, for setting aside an award or getting an award remitted for reconsideration. 30 days from the date of service of the notice of the filing of the award, your lordship. So under Article 119B, your lordship, period prescribed is 30 days. And that 30 days, your lordship, runs from the date of service of notice of the filing of the award. Now, your lordship, the trial court dismissed my petition under section 17, after which your lordship, I presented a revision petition before the Honorable High Court that limitation actually it expired before the filing of the objection itself. So both the trial court and High Court, your lordship, rejected my prayer and found, according to the Honorable Court's High Court's order, that my objection under section 17 is, it is premature. It is premature and it is within time and they can file objection. As against that, your lordship, I went to Supreme Court.
In that, this judgment was.
This judgment has been delivered. The Supreme Court has held that when the petition under section 30 of the.
So 22/9/2022, the limitation starts.
Starts, your lordship, and 21/9/2022, from that, your lordship, it is 29/2010, your lordship, 22 is the
Limitation
last
starts.
date, your lordship. Within that, your objection was not filed. Within that, objection was not filed. But peculiarly enough, your lordship, when the Supreme Court delivered the judgment in open court, your lordship, they never took the leave of the Honorable Court, your lordship, that they have already filed objection before the trial court, that is the district judge Sonitpur, and along with the objection, they have not filed any condemnation petition. Because condemnation petition, your lordship, it should be accompanied with the objection, your lordship. It is somehow, your lordship, delayed. Now, there was no condemnation petition, your lordship. After the Supreme Court delivered the judgment on 3/1/2025, your lordship, they filed the condemnation petition, your lordship, that too after 4 months. And these things are available, your lord, from the records and as well as from the judgment of the Supreme Court. Supreme Court judgment, your lordship, it has stated all the facts in details. It has stated all the provisions of law, your lordship, and the rules applicable so far this arbitration matter is concerned, your lordship. All facts and laws, your lordship, has been discussed by the Supreme Court. That's why, your lordship, this Supreme Court judgment is very relevant for the purpose of whether the condemnation petition under section 5 was rightly dismissed or it ought to have been allowed, your lordship. And the trial court has held, your lordship, that this is a matter, the condemnation petition which has been filed, not only it is delayed, but it is very any sufficient cause. So there is no sufficient cause, and before the Supreme Court, they could have taken the plea that at least we should be given leave, your lordship, to file a condemnation petition under section 5, your lordship, though it is belated. So that sort of leave was not taken from the Supreme Court, and thereafter also, your lordship, they have not taken it either from the High Court or for the Supreme Court. The trial court, your lordship, will be coming to that, your lordship. And as the condemnation petition was not allowed, rather it was dismissed, your lordship. So the objection which was filed by them, your lordship, that was of no consideration, it was not consent, that was dropped, your lordship. Now, your lordship, I am placing paragraph 8, your lordship, on at page 70, your lordship.
Para 8 of Apex Court's
Lordship, your lordship. On 10/11/2022, the appellant filed an application. Appellant means this respondent under section 70 of 1940 Act, bearing Meets case number 61 of 2022 before the district judge, Sonitpur, seeking pronouncement of the judgment according to the arbitral award. the district court dismissed the appellant's application filed under section 17 by the order dated 23/11/2022, holding it to be premature, filed before the limitation for filing the objections to the award could expire. According to the court, the limitation began only on 18/11/2022. What is that, your lordship? 18/11/2022 is the date, your lordship, on which date he paid the balance amount to the arbitrator, as well as he obtained a copy of the award, your lordship, from the court. And notice was given to him, your lordship, during the year. So he has actually considered that 18/11/2022 is the date of his knowledge of filing the award before the court, your order, and under that conception, your lordship, he took it that as it is 18/11/2022, so 30 days period he has counted, your lordship, up to 17/12/2022, your lord, which according to the Supreme Court, it is beyond 30 days. And that is not within the period prescribed under Article 119B. I am reading, your lordship. According to court, the limitation began only on 18/11/2022 when the formal notice of the award was received by the respondent, and the application to pronounce the judgment according to the award was filed only on 10/11/2022, when the limitation period of 30 days was still running at the said point of time. 10. Questioning the above referred order, that is, your lordship, passed by the district judge, the appellant filed a civil revision petition before the High Court, being number 138 of 2022 under section 115 Code of Civil Procedure 1908 before the High Court. By way of the impugned order impugned before us, the High Court dismissed the revision and upheld the district court's order. The High Court also held that the application for pronouncing the judgment according to the award was filed during the subsistence of the period for objection by treating 18/11/2022 as the date as notice of filing the award. It referred to the text of section 14 and 17 of the 1940 Act, as well as the Article 119 of the Civil to the Limitation Act 63 to hold that only a formal notice issued by the court will satisfy the requirement of section 14(2). So 14(2) they interpreted, your lordship, the district judge as well as the High Court, your lordship, that under section 14(2), where a notice will be served upon the party, your lordship, that is the award debtor, your lordship, under the Arbitration Act, your lordship, in place of judgment debtor, your lordship, they are named as award debtor. And in place of decree holder, your lordship, it is award holder, your lordship. Anyway, your lordship, this judgment debtor or, your lordship, award debtor, that is the present appellant before your lordship. So the board, the courts, your lordship, took the view and interpreted section 14(2), your lordship, in the way that when the notice was served upon them under section 14(2), and this has been interpreted by the Supreme Court now, while he was directed to pay the balance amount with a direction to obtain a copy of the award which has already been filed before the court, that is the awareness and that is the knowledge, your lordship, and that is the notice itself, your lordship, and he is to file the objection, your lordship, within 30 days from 21/9/2022. This is the sum and substance of the Supreme Court judgment. Now, your lordship will come This submission is not necessary, your lordship. All facts and laws have been discussed. Lordship, I'm coming directly to the paragraph, your lordship.
19,
Lordship,
para 19.
lordship. Para 19, your lordship. Applying these principles to the fact of this case, it is seen that both the district court and the high court fell into error. That the limitation for filing objection was still running when the appellant filed an application under section 17 of the Act on 10/11/2022. The formal date of notice of filing the award on the respondent, that is 18/11/2022, holds no significance, as they were made sufficiently aware of the awards filing on 21/9/2022 itself. The court directing the respondents to clear the fees as was clearly intimation about its filing. Holding otherwise would not only be departing from the procedure of this court, but also allowing the respondent to take advantage of their own inaction.
What happened on 21/9/2022?
21/9/2022. Lordship, on the petition of the present respondent, your lordship, which was filed under section 17, that judgment should be that
What should be made?
Union of India should be directed to pay the balance amount to the arbitrator. Because award is ready, award has been filed, but they are not obtaining the award, you will say that why?
No, thereafter, what happened on 21?
On 21/9, your lordship. That is 20.
Whether any notice was issued?
21/9/2022.
Yes.
Your lordship did order itself, your law, it was the direction, and that direction, according to the Supreme Court, is a notice. You have got, that is the notice, because you have got the awareness. You were aware of the order dated 21/9/22. You were aware of the fact that the award has been filed in court, and that is sufficient that you have been served notice under section 14(2) of the Arbitration Act 1940, your lordship. That itself, and it has been interpreted that way, your lordship, that no further notice is necessary under section 14(2) of the 1940 Act. So under section 14(2), your lordship, further notice is not necessary because you are aware of the fact that the award has been filed, it is pending before the court. Only thing that you have not collected the award by paying the balance amount to the arbitrator. So you have evaded. That's why, so you pay first, and this is the knowledge for you that award has been lordship pending before the trial court, that is the district judge, your lordship, and that itself is sufficient and no further notice is necessary. That being the position, your lordship, Supreme Court has held, holding otherwise would not only be departing from the precedence of this court, but also allowing the respondent to take advantage of their own inaction. Hence, the limitation is to be treated as expired on 20/10/2022. And the appellant's application seeking pronouncement of the judgment in terms of the award was valid and well beyond the period of filing the objection to the award. So it is well beyond the period of filing of the award, and that's why under section 17, whatever has been paid by the present respondent, your lordship, that is within his jurisdiction within time, your lordship, and that ought to have been allowed, passing your lordship, judgment and decree by the trial court in conformity with the award given, your lordship, or award as submitted by the arbitrator.
That section 17 petition is still not decided.
That is Miss J case number 61 of 2020.
No, whether it is still pending.
It has been disposed of, your lordship, by the by the trial court, your lordship, when it was disposed of, the petition under section 5 of the limitation. I am coming to that, your lordship. I'll be coming to that.
Okay.
Now, your lord, 20, conclusion. In the light of the above, we allow the present appeal and set aside the order dated 27/3/2024, passed by the Honorable High Court in Civil Division Petition number 138 of 2022. 21. In facts and the subconcept, there shall be a direction to the District Judge Sonitpur, Tezpur, to take up and dispose of the Miss J case number 61 of 22 as expeditiously as possible.
Major case number 61 means 17 petition.
Correct, your lordship. Correct, your lordship. 17th petition that was pending at that time. So that petition was registered under Miss J case number 61 of 2022 as expeditiously as possible, preferably within a period of 5 months from the date 3/1/2025, because the judgment was delivered on 3/1/25, and it is the contested case, your lordship, before the Supreme Court, and it was within the knowledge of Union of India, because they
Okay, what happened thereafter?
within 5 months, your lordship, it is to be delivered. Now, your lordship, the trial court has no option but to decide the Miss J case number 61 of 2022 within 5 months, and it has decided, your lordship. Now, your lordship will come to the impugned order, your lordship. Impugned order is at page 83, your lordship.
This order is passed on which application?
This 23/6/2025.
This order is passed on petition number 1094.
This, your lordship, will come to page 83, Miss J case number 58 of 2025.
Yes, where is that petition 1094? You have annexed it.
Your occasion, Honorable Court, yes, call the LCR, but that LCR, that petition is not there, my lord. I have seen that petition also. That is not there, LCR. I have seen the LCR, my lord. That's why, because of this petition, Honorable Court called that LCR, my lord.
What was the petition?
That is the petition for
Petition
limitation
of
of
eight,
illegal.
copy of it.
You have a copy of that?
Don't have now, but it is reflected in page number 83, my lord.
No, 83 I have seen.
Yes, my lord.
But where is that
It is the
petition?
order, but they ought to have annexed the petition.
Petition
your
also.
lordship,
Yes,
along
my
with
lord,
the,
that is true, my lord, but,
petition.
but
But they have
for
not
this,
done
my
it.
lord,
they have not done it. Anyway, your lordship, I am performing their duties, your lordship.
Yes,
We have got copy, your lordship.
thank you.
Because this objection will be raised by the honorable court, that why you have not annexed. And after going through the brief, your lordship, we have also found that they have not annexed.
Okay, by the impugned judge order, this petition was dismissed.
This condemnation petition under section 5 of the limitation, it was dismissed, your lordship. And this is Miss J case number 58. 58, and when it was dismissed, your lordship, this condemnation petition, automatically, your lordship, the objection which was filed, that is the Miss J case number 61, that was dropped, your lordship, as because the condemnation has not been allowed. So this judgment, your lordship, it will throw light upon the matter, your lordship. May I read it, your lordship?
No, Ms. J case number 61 was dropped.
Lordship, that is later on, Your Lordship.
No, how 61 can be dropped?
Yes, Lordship.
61 is a petition, a miscase under section 17 filed by you.
Your Lordship. That is order is there, Your Lordship. For the crossing.
What happened to 17 petition? Yes.
You want to say?
Page number 88.
58, no?
Yes. Relevant portion in page number 98, this has been disposed of accordingly.
You want
88 to
11
98.
page number?
Oh,
This is the petition under section 17. Page number 88 of my appeal.
So detail order under section 5, Your Lordship, it is at page.
okay, okay. 17 petition was allowed. 17 petition, miscase was renumbered as
Yes,
miscase
but-
14.
Your Lordship, it was 14, Your Lordship.
14,
14, previously it was
61.
number 61.
Hmm.
So this,
That petition was allowed and decree was prepared.
so
Now they have come again against
again, the dismissal of
the delay condonation
the
application.
delay condition as well as Your Lordship that we check case number 61, which was allowed, Your Lordship. Again, that they have come here. Now, may I read the that is the order that is this disposal of this section 5.
In this appeal, what they have impugned,
They have informed both 23-6.
both the orders.
Yes, ma'am.
So if the conditional petition goes, Your Lordship, then there is nothing. Because objection will go, Your Lordship.
On what ground you are objecting to the order dated 26, 23, 6, no, page number 80,
83.
not 83, 87, 88.
Yes. 88 is a petition of under section 17. Yes, ma'am.
What ground you are object?
We object, my lord, the Supreme Court has, this is a fact that there is a delay in filing the appeal under section 30, my lord. This is the fact settled by the Supreme Court. After that, my lord, immediately, because our case, our arbitration award, that is in the LCR, my lord, from case number 1, that is our award, my lord. Miscellaneous arbitration 7/2022. That is registered on that day, my lord, that is on 19/12/2022, my lord. This, that is the award under section 30 petition, my lord, against the award of the arbitration. Then, my lord, immediately after the decision of the Honorable Supreme Court, my lord, we have filed our petition under Limitation Act, my lord. And under Limitation Act, our ground for condoning the delay is that since the case is pending, that before the High Court also in our favor, District Court is also in our favor. So we are also under impression that the limitation will be start from the date of issuing the notice. But Supreme Court held that no, the limitation will be start from the date of the knowledge. So considering that, we have immediately filed our application under Section 5 of the condonation of the delay. And ground is for condoning the delay ground, all the grounds are related to the case, my lord. So we are the layman, we are under impression that limitation will be start from the date of notice, my lord. So that is our ground, my lord, main ground to silence the condoning the delay, my lord. And kindly see, my lord, page number 87, my lord. Case number 87, Miss Arbitration 4 of 2025. This earlier it was Miss Day number 7 of 2022, my lord. That is, kindly see the language of the Honorable Court, my lord. Today is the date fixed for necessary order. Both parties represented. The application filed by the petition under Section 30 of the Arbitration and Conciliation Act 1930 has not been considered in view of the order passed in Midday 58 of 2025 filed under Section 5 of the Limitation Act, whereby the delay has not been condoned by this court.
So your 30 petition was barred by limitation.
Barred by limitation. So that's why we have filed our application under Limitation Act, and grounds are not attributed to us, my lord, because High Court and as well as the District Court the observation that limitation will be start from the date of the issue of the notice, not from the
High Court and District Court were wrong.
Yes, that were wrong. But as a litigant, my lord, how can one person can know that from where the limitation will start? We are on that.
Union of India, your lordship, how can it be said layman, your lordship? They are having.
Even the High Court in
full
our
page
favor,
office.
my lord. High Court said that limitation will be start from the date of the notice, my lord.
But High Court was wrong.
That High Court was wrong. I am on that, my lord. Yes, High Court was wrong. That Supreme Court held that High Court was on wrong. But since the High Court is and that is pending before the High Court, my lord, that is pending before the lower court also, my lord. So that is the main ground of challenging the for condoning the delay, my lord. Because kindly see, my lord, I have good judgment, my lord.
Suppose your objection against this
Award.
not award against the delay condonation application is not taken care of or dismissed, then there is nothing to object against award.
So no objection. It amounts to no objection.
Because you have challenged two orders. Your challenge to the second order is dependent upon allowing of the first challenge. If first challenge is dismissed, then say.
Kindly see the observation, the ground of dismissing the petition, my lord.
Yes.
Kindly see page number 85, my lord. That is 86, my lord, from the second para. The petitioner excused that region were beyond their control and is not only vague but also misleading. Once the petitioner was aware of the filing of the award, there was no legal or factual impediment preventing them from approaching the court within the stipulated period. The reliance on 18/11/2022 as the date of knowledge is self-serving presumption devoid of merit and contrary to the settled legal position. It is expected of the litigant to be aware of the law, not to fabricate their own version of limitation. Accordingly, grounds cited in the support of delay are found to hollow, ill-founded, and lacking in bona fide. This is clearly not a fit case for exercising discretion under Section 5. My lord, the same court, then kindly come to page number 58, my lord. 58, my lord. Means 61 2000 order of dated 23/11/2022, my lord. Yes, 58, my lord.
Yes.
Now, when the relevant portion is page number 59, last paragraph, my lord. May I read, my lord?
Yes.
Having considered the relevant provision of law referred to above on careful consideration pleading of the both sides, what is the prominent before this court is that the respondent pleaded that they received the notice of the award in terms of the order of this court in Mise number 37 2000 on 21/9.
This was found to be wrong.
That is
earlier.
that my submission is that, my lord, when the decision of the court is how can, my lord, one litigant can know that what the law, my lord. That is my position, my lord. This is the main issue here, my lord. That even the district court has said that that will come from the limitation will be come from the notice, and High Court also says that for the litigation this is not that attributed to them, my lord, for the appellant, my lord. Because High Court said that yes, limitation will be start from the date of the date of the receipt of the notice, my lord. That is wrong, my lord. I am on that. Yes, that is wrong from as held by the Supreme Court, my lord. But still they are pending before the court at that point of time, my lord. And my lord, the ground for challenging this that limitation, my lord, that is only ground that they are litigant, my lord. When High Court and as well as the district court the observation in the same, my lord, so how can they know, my lord, the law, my lord, then as a litigant, my lord? And the same court, my lord, kindly see page number 59 and 86, my lord. In one hand, court says that yes, my lord, the limitation will be start from to the date of issue of notice, and the same court and says that this is the negligence of
What is saying after Supreme Court?
yes, Supreme Court said. But this that is the, my lord, court says that, my lord, at that point of time. Yes, my lord, after Supreme Court said, my lord, that the Honorable District Court says that yes, limitation will be that there is a negligence. But negligence for whom, my lord? Kindly, that is the case 59 is also in the part of negligence, and my lord. So we are we should obey the order of the court, my lord. Page number 59. At that point of time, this is in force, my lord. Page number 59. And High Court order is also in force at the point of time, my lord. Only after only after the Supreme Court order that was settled, my lord. That is not only our fault, my lord. That
Your memo of appeal, where is the ground?
my lord, kindly see. Page number 11, my lord.
What is the first ground?
From this, my lord, we have filed that appealment that is for the land considered a preliminary raised by the applicant on the ground of maintainability. That is on the maintainability, my lord, of the award, my lord. The appellant makes that initially there was a conflict between SR Engineering and Union of India. SR Engineering was represented by the contractor Sukharam Himan. From the document number 1, it appeared that
Why it is not maintainable?
because, my lord, that the present petitioner is present respondent is not the contract. He is not the.
No, where is the ground regarding
Delay, my lord.
delay?
Yes, ma'am, come to that.
Mhm. Mhm.
Kindly come to page number 53, my lord. Para number 14, my lord.
Page number
53, para number 14.
yes.
For that the learned court will fail to consider ground of the petition for confirmation of delay of 56 days. The arbitration has passed the award on 31/5/2002 in connection with the arbitration case number 1/2019. Accordingly, filed the objection on 16/12/2022. In the meantime, the respondent prepared the Ms. 61 under section 17 of arbitration to pronounce the judgment according to the award dated 31/5/2022. According to the respondent, statutory period to file the objection against the award expired on 2010-2020. Honorable District Judge rejected the application under section 17 of the Arbitration Act, and respondent thereafter approached before the Honorable Gauhati High Court challenging the order of the District Judge Sonitpur Tezpur. The Honorable High Court dismissed the civil division petition filed by the respondent, had order dated 27/3/2024. The respondent preferred an SLP before the Apex Court, and Honorable Apex Court allowed the SLP had order dated 3/1/2025 held that the date of issue of notice on 18 was deemed to be inconsequential, and the respondent has already been sufficiently apprised of filing an award for the court order dated 21/9/2000, which had directed them to clear the arbitration. Accordingly, the limitation period expired on 22/10/2020. In view of the above, Honorable Court set aside the order dated 27/3/2000 passed in CRP number, so remanded back the case to Director the District Sonitpur to take up the decision to dispose of the matter. So that is my ground, my lord. This is the limitation we explained why there is a delay to filing the the petition under section 30, my lord. I am not on that. Yes, that is the fact. Is there is a delay, but condonation of delay, my lord, the rejection on which ground they rejected our petition under delay condonation, my lord, that is not reasonable, my lord. Because in that period,
Before the trial court,
yes,
in the application which is not with you now, what plea you took?
that is the same plea we took, my lord. Only that is also in page number. Page number 83, some of the paragraphs are reflected in page number 83, my lord. Yes, sir. Yes. Yeah, that's page number 83, my lord. Yeah, I did from page number 83, my lord.
Take this.
But
What was the main contention?
in context, from page number 4, my lord, the applicant makes the opposite party petition is the case number page number 2 of my delay condonation petition, my lord. From page number 3, my lord. The applicant has filed an objection against the award dated 31/5/2020 passed in arbitration case number 1/2019 under section 30 of the Arbitration and Conciliation Act 1940. The applicant received the notice from the Honorable Court on 18/11/2022. The objection against the arbitration case number 1/2019 has been filed on 16/12/2022, which was registered as a mistake case number 7/2022 on 19/12/2022. The applicant begs to tell the opposite party prepared a mistake case number before the learned court below, praying for set aside the order dated 20.
Then the process.
The process we have stated in our petition, my lord.
But Apex Court held that the note, you came to know about award when you were directed to deposit the arbitrator's fees. Arbitrator's fees. From that point, your limitation starts. So you have to explain.
No explanation.
My lord, but we could not explain before the district court because, my lord, at that point of time, we are under impression that that will come from the date of from the date of issue of the notice, my lord. So under impression that we are not barred by the limitation, my lord, at that point of time. That is our main case, my lord, before the court. That's why we could not file at that point of time because we are under impression that that will come and kindly see, my lord, there is another case, my lord, before the lower court that is still in force, my lord, as that is case number case number 60, my lord.
Which number?
60, my lord.
Yes, what is this?
This, my lord, is the one of 2000 filed by the respondent, my lord. And according to them also, my lord, kindly see their contention. This order appertaining to petition number 5 of 2020 dated 3/1/2000 filed by Srimati Krishna Devi Sabitri Devi under section 14(2) and 17 of the Arbitration Act 1940 on the ground of filing petition by the respondent after the period of limitation for setting aside the award published by the sole arbitrator on 31/5/2022. The contention of the petitioner is that against the order dated 23/11/2022 passed by this court in Mizze case number 61, the revision petition has been preferred in the Honorable High Court being revision petition number 138, which is pending for decision. But the present petition has been filed on the fresh cause of action arose in 14/11/2022. It is contended the respondent filed the objection to the award only on 19/12/2020, which is beyond the period of limitation as per 119B of the Limitation Act 1963, as the period of limitation expired on 13/11/2022 from the date of the service of the notice from the court. Since the objection is required to be filed within the 30 days from the date of award, whereas the same was filed on 19/12/2022. This is also the pleading of the respondent before the district court also, my lord. They also expect that, yes, that according to them also, my lord, that the date will expire from 19/12/2022, my lord. Not the 10, my lord. That is their contention, my lord.
Okay, but Supreme Court has laid this to rest. That from when limitation will start, it has pointed out. Therefore, you have to explain the delay from that point, which has been pointed out by Apex Court.
Yes. Yes, on that point, my lord, page number 6 of that petition, my lord, delay condonation petition, my lord. Paragraph 12, my lord.
Yes.
That the applicant begged to state that the opposite party filed an application before Honorable District Judge under Section 38 of the Arbitration and Conciliation Act 19 for dispute as the arbitrator fee and cost. The Honorable District Court passed that award order dated 21/9/2022 in Midset 37/2022. The arbitrator has passed the final award in terms of the order of the District Court and submitted the same before the court in seal cover. By the order said order, the Honorable Court directed to pay the balance amount to the arbitrator. The Honorable Court further observed that on the depositing the balance amount by the applicant, respondent in court, the copy of the award may be furnished. At the same time, copy of the award to be furnished to the opposite party as well forthwith. But in spite of the above observation, the opposite party collected the copy of 22/9/2000, which was kept in the seal cover. The said amount was paid on 21/11 to provide the check number for an amount of rupees 47,000 so and so. Immediately after depositing the amount, the applicant collected the copy on 23rd November 2022. The applicant, after getting the copy of the final award, filed an objection under Section 30 of the Arbitration and Conciliation Act 1940. On 16/12, considering the fact and law that the limitation shall start from the service of notice under Article 119 of the Schedule of the Limitation Act 1963. As per observation of the Honorable Apex Court, the limitation start from 21/9/2022 and the application under Section 30 ought to have been filed on 22/10/2022.
Okay. Anything else?
I have one attachment for condoning the delay, my lord. Yeah, my lord. Relevant portion is from in paragraph number 20, my lord, of page number 6, my lord.
Yes. What it says. Para 20. What?
20, my lord, P that it may, on account of labor having been granted the appeal. Be that, my lord, it may, on account, para number 20, my lord.
Yes.
On account of liberty having been granted to the appellant to pursue his remedy in accordance with law, yet another way that so and so, along with an application for condonation, they came to be filed. The delay was not condoned by the tribunal on the ground that it was filed more than 1 year after the impugned order came to be passed. No litigant stand to benefit in approaching the court belatedly. It is not the length of delay that would be required to be considered while examining the plea for condonation of delay. It is clause for the delay which has been pronounced will have to examine if the cause for delay would fall within the four corners of the sufficient cause, irrespective of the length of delay, same deserve to be condoned, and however, if the cause shown is insufficient, irrespective of the period of delay, same would not be condoned. Here, my lord, sufficient cause is there, my lord.
What is the sufficient cause?
Sufficient cause is, my lord.
That you are under impression that
My lord, that will delay will come from the date of issuing the notice. The notice was issued on as per the section in order in page number 58. According to the court, the notice was issued on 18/11/2022, page number 59, my lord. Earlier notice was not issued, my lord. Page number, according to the court, notice was issued on page number 59 in the last paragraph, my lord. Yes, there is knowledge, but notice, we did not get the notice from the court, my lord. And as per the section article 119 from the issue of notice, my lord. But Supreme Court is clarified that not from the date of knowledge. That is true, my lord. But before that, we were under that impression, my lord. When we get the notice, immediately after that, we have filed that award dated award under section 30, my lord. That is the sufficient cause, my lord.
okay, if order dated 23/6/2025 at page 83 is set aside, then then page 88 order would automatically be, because it has not considered your objection. Okay.
And my lord, kindly see in page number, the order dated for 23/6/2003 in arbitration 4 of 2025. There is there is nothing regarding the page number 87. There is, in that order also, there is nothing about the section 6, for the section 17 case, the court has dismissed our case, my lord. They have dismissed simply only on the ground of.
No, because that was barred by limitation.
That is, yes, not on, yes, my lord, that is, they considered only the section 58, the condonation petition, my lord. Only considering that they dispose of our award, my lord.
Yes, unless delay is condoned.
Yes, my lord. And there is no reflection of the Supreme Court order in the delay condonation petition also, my lord.
You have, in this appeal, you have challenged which orders?
We have challenged, my lord, both this Ms. 58, and misapplication 4 of 2025, my lord.
Not Miss 14 of 25.
That is also, my lord, subject matter, my lord, that is in our cost title, that is there also, my lord. Miss A 14 also, my lord, in page number 2, my lord.
What is the prayer?
In type of case, arbitration allowed the order dated 26 in lease arbitration for be set aside and quash, my lord. If that requires, my lord, automatically all the cases will be, my lord, closed, my lord, because that is the main order arbitration number 4 of 2025, my lord. 4 of 25 is considered on the ground of delay condonation petition, my lord. In in 4 of 2000, in order date 23/6/2023.
Only 4 of 20.
Yes.
Yes, Mr. Ali. What is your response?
Right, from the trend of the facts, that all along they are found to be negligent, dereliction of duty, your lordship, and inaction. Your Lordship will find this is a contract of the year 87-88, and it is Lordship 2026. For last 38 years, Your Lordship, a contractor is fighting for justice and for realizing the amount. And this sort of facts, Your Lordship, have also been considered by the Supreme Court. Supreme Court, that's why, Your Lordship, prescribed the time limit for the trial court that within 5 months you are to dispose of the petition under section 17. Whatever may be the result, Your Lordship, but it should be disposed of within 5 months. Now, Your Lordship, the Supreme Court passed the judgment on 3/1/25, and they filed a condemnation petition, Your Lordship, 3/5/25, that is after 5 months.
No, man.
After 5 months, Your Lordship, they have filed a petition on
There's a picture.
3/5. Not that, Your Lordship, just after the Supreme Court delivered the judgment on 3/1/25, they filed a condemnation petition. There is also delay of 5 months, Your Lord. So from the cumulative effect of their actions, Your Lordship,
When they filed condemnation petition,
on 3/5/2025, Your Lord. That is there, Your Lordship.
3/5/25.
Lordship.
And when the
Lordship, the copy which we have
Supreme Court order is.
furnished to Your Lordship, Your Lordship will
Supreme
find
Court
that is
order is
3/5/2025. That is seal is there of the trial court, Your Lordship, on the petition itself. From that, Your Lordship will find it is 3/5/2025. Supreme Court judgment is 3/1/25. That petition of condoning delay, there is also delay of 5 months, Your Lordship. So if this way your things are allowed to go, Your Lordship, then will be the justice, Your Lordship.
and when they filed section 30 petition,
Lordship,
date of filing of section 30 petition.
Date of
Section
filing the
30
section 30
petition.
petition is on.
it is, Your Lordship, 18/11,
19/12/2022.
18/11/2022.
19/12.
18/11/2022, Your Lordship. And the Supreme Court has prescribed the period for dispose of the petition, Your Lordship, that is section 17 petition, Your
And
Lordship.
delay condemnation they have filed on 3/5/2025.
Lordship, after 5 months, Your Lordship. On their part, Your Lordship, except delaying the matter, there is nothing, no merit, Your Lordship. This is the arbitration proceeding, Your Lordship. It is not like a civil court, Your Lordship. Detailed procedure need not be followed. It is the arbitrator who will decide, Your Lordship, on the basis of the record and somebody's evidence is concerned, Your Lordship, not to be followed strictly. Not to be followed strictly in arbitration matter. And if things goes like this, Your Lordship, this is the alternative remedy. These arbitration proceedings are alternative remedy, Your Lord. Alternative remedy, not the regular procedure, Your Lordship, regular proceeding. And if that proceeding takes time, Your Lordship, since, say, Your Lordship, 3/1/22, Your Lordship, since then, Your Lordship, it is that the original contract is of the year 87-88. The cumulative effect is, Your Lordship, they are not entitled to get any sympathy from the court, and if they are given any, as the Supreme Court has held, that it will be given an extra advantage to the other side, Your Lordship. They will be given, Your Lordship, extra benefit, extra advantages, Your Lordship, to delay the matter. That is the Supreme. I'm just reading that part of the matter, Your Lordship. I'm coming. Paragraph 19 of the judgment.
Okay.
Lordship, I am coming. We find that the interpretation in this section is in line with the intent so and so, which is designed to resolve the dispute as quick pace as at a quick space, any contrary interpretation will give license to the award debtor. License to the award debtor to delay the arbitration by insisting on procedural nuances, despite being aware that an award exists and that its contents are accessible to him. Now, your lordship will find this conclusion. Also, your lordship will find that it is to be disposed of within 5 months. The court has no alternative, this trial court. Court within 5 months, your lordship, it has disposed of. It has disposed of lordship and the petition, condemnation petition, your lordship, except narrating their inaction, your lordship, negligence, dereliction of duty, your lordship, there is no other explanation which can be called, your lordship, sufficient cause. This is not sufficient cause, your lordship, that whatever you will state, in this regard, your lordship, I am placing 2 decisions of the Supreme Court, your lordship. It will go by. So whatever facts they have stated in the condemnation petition, this is nothing but narration of their mistakes, the omission, commission, your lordship, inaction, dereliction of duty, negligence, your lordship, and that the cumulative effect is that, your lordship, they are not prepared to pay the contractor, your lordship, the amount for which they have performed the duties, performed the contract. Lordship will find this 1994 supplementary 2 SCC 696.
Para?
There's a single para, your lordship. 1994, your lordship.
Yes, yes,
Lordship,
yes.
there is an inordinate delay in filing this special petition order. The only submission made by the learned counsel for the petitioners raised on the amendments in the application for condemnation of delay is that the relevant file was misplaced for quite some time in the office of the central agency, and these special petitions were filed after some delay, even though the file could not be traced. There is nothing in the application for condemnation of delay to indicate the action taken to find out how the file got lost or to fix the responsibility on someone who should be accountable for the same. Learned counsel even today is unable to indicate the same. We also inquired whether any action has been taken so far to identify the person responsible for the lapse and to fix responsibility for the same. Apparently, no such action has been taken as yet. This being so, a mere statement that the relevant file was lodged in some office can be treated as sufficient cause for condemnation of inordinate delay. It may have been a different matter and the logical action been taken by the petitioners to identify parties responsible for the lapse and the necessary action taken against him while ensuring further non-repetition of similar lapses, which we are sorry to say are not uncommon in the special petitions filed by the Union of India. So, Union of India, your lordship, it is not only the case, your lordship, every case, your lordship. In land acquisition matters, your lordship, other matters, your lordship, contract matters, your lordship, in all matters, your lordship, except delaying the matters, your lordship, though they are having a full-fledged, your lordship, legal cell. They are not capable of lordship instructing what is to be done by the council engaged your lordship. We are constrained to make this observation in view of the fact that SLP filed on behalf of the Union of India are quite often barred by time. An application for cancellation of delay is made in casual and routine manner without indicating facts which could constitute sufficient cause to permit continuation of delay in accordance with law. IF number so-and-so continuation of delay are rejected. Consequently, the special leave petition are also dismissed as time barred.
Okay.
So this is the natural habit of the Union of India, your lordship, that
cannot.
after having performed the things, your lordship, that they are not to be paid, your lordship, and everything, your lordship, in a slipshod manner, your lordship, they are dealing with. Otherwise, your lord, how can you take, your lordship, 38 years? They are to pay, your lordship, as per the arbitration award, your lordship, they are to obey the court's order, your lordship. They are not obeyed. They are not giving even the arbitrator's fees, your lordship. Union of India, they are the richest entity, your lordship, so far the litigation is concerned. And because of these events, your lordship, this Union of India or the state government, they are the common litigants in all cases, your lordship. 32 or 30,
Okay.
226 or 32 of the Constitution of India, your lordship. It is
In your application under section 30, what objection you have raised? Brief one, you need not to read out.
Yes, madam. That is, first
lordship,
objection is that
other
is
decisions, your lordship, filed.
By,
Other,
by you. Oh, yes, second decision.
second decision, your lordship, that is 1999 2 SCC 400. The lordship will find paragraph 17, 21 and 22. At the top of the page, your lordship, I have noted.
Yes, what it says, similar.
17, your lordship. 17 at page 408, your lordship will find. 17, your lordship got it.
Yes.
For the aforesaid reasons, the High Court has rightly quashed the prosecution proceeding in the strength of the certificate of the Director of Central Court Laboratory, which has come on record in the case. So this special petition is barred by so-and-so. It is against the order.
But this is dissenting judgment which you are reading.
Not dissenting, your lordship. The other judgment on different point, and this judgment is, your lordship, on this limitation point, your lordship. Not dissenting, your lordship. The other points, the other part is, your lordship, so far the closing of the proceeding is concerned, and so far limitation is concerned, your lordship, this is the judgment by a third judge, your lordship.
Okay.
Lordship, I am reading this sub-para, your lordship. In constituting section 5 of the Limitation Act, it is relevant to bear in mind two important considerations. The first consideration is that the expiration of the period of limitation prescribed for making an appeal gives rise to a right in favor of the decree holder to treat the decree as binding between the parties. In other words, when the period of limitation prescribed has expired, the decree holder has obtained a benefit under the law of limitation to treat the decree as beyond challenge, and this legal right which has accrued to the decree holder by lapse of time should not be light-heartedly disturbed. The other consideration which cannot be ignored is that if sufficient causes for excusing delay is shown, discretion is given to the court to condone delay and admit the appeal. This discretion has been deliberately conferred on the court in order that the judicial power and discretion in that behalf should be exercised to advance substantial justice. As has been delivered, so section 5 of the gives the court a discretion.
In this case, Mr. Ali, in this case, their main ground is that they were under a mistaken impression that limitation starts from a later date.
Our case, Your Lord.
In the instant case, the Union of India was under a mistaken impression as to when limitation, since from what date limitation will start, and which was also supported by the judgment given by the district judge as well as High Court, though ultimately it was overruled by the apex.
What about your Lord's filing of the condemnation petition after 5 months? What explanation they have given, Your Lordship?
No, condonation
That has not
petition,
explained.
condonation petition,
In Your Lordship, that at their whim's caprice, Your Lordship, it will be filed after so many years or so many months, Your Lordship.
condonation petition has been filed after almost 3 years. 22, you filed the original petition. In 25, you filed. But when the matter was before Supreme Court, you did not inform Supreme Court that we may be allowed to file a
Lordship,
condonation
they-
petition.
take the leave of the Supreme Court, Your Lordship.
So how will you explain filing of condonation petition after
Let them go to Supreme Court.
2.5 years? The 30 petition was filed on 18/11/2022, and delay condonation was filed on 3/5/2025.
Yes.
Okay. Have you made any statement in delay condonation application or in this memo of appeal that why this delay was caused? Delay in filing condonation petition.
That is.
Similarly, Supreme Apex Court's order was on 3/1/2025. From that date also you filed after almost 4 months.
More than 5 months, Your Lord. And these are arbitration matter, Your Lordship. There is no such point they have raised that they say award is actually expressive, or from the very reading of the award that there is some defects or illegalities, infirmities, irregularities, Your Lordship. It is not that case, Your Lordship. Amount is not such a big amount, Your Lordship.
Amount is a big amount.
Not big, Your Lordship. 1 crore, Your Lordship. It is a big construction, Your Lordship, this arrangement, Your Lordship. Of the year 87, 88 itself, Your Lordship. Some payment has been made, thereafter the matter was referred to the arbitrator.
Yes.
Arbitrator found that this much of amount, Your Lordship, it is still to be paid.
And Ms. A. Gayan, Learned Central Government Council, appearing for the appellant. Also Mr. S. Ali, Learned Counsel for the respondent. This appeal under Section 39 of the Arbitration Act 1940 has been filed by the appellants impugning the order dated 23/6/2025 passed by the Court of Learned Civil Judge within bracket Senior Division Sonitpur Tejpur in Miss Arbitration Case number 4/2025, whereby the application filed by the Union of India under Section 30 of the Arbitration Act 1940 was dismissed on being barred by limitation. The facts, next para, the facts relevant for consideration of the instant appeal, in brief, are that who is the respondent?
Sole respondent, Your Worship.
Respondent is Krishna Devi.
Your Lordship,
Yes.
Krishna Devi versus Savitri Devi, Your Lordship, alias.
Who approached the Supreme Court?
Supreme Court, Your Lordship.
Guided respondent, my lord. Krishna Devi.
Krishna Devi, Your Lordship, the proprietor's wife, Your Lordship. It is the,
Why proprietor himself did not approach Supreme Court?
this is dead, Your Lordship.
Okay.
That is one of
He
the
is
grounds
expired.
of challenging the award also, my lord. Here, my lord, what happened, my lord, that proprietor is FI Engineering and Krishna Devi and is the wife of the proprietor. That is one of the, he is no longer, he is, that is why, that is our submission that is not maintainable, my lord. That is one of the.
However, that is the proprietorial firm, Your Lordship. Proprietorial firm represented by proprietorial.
That the husband of the present respondent was the sole proprietor of Messrs. SR Engineering Construction, which had secured a work order bearing CA number CWE/TZ/8 in 1987-1988 from the present appellants. The work order was governed by the general condition of contract, of which clause 70 contained an arbitration clause. The agreement involved the firm constructing a permanent armament section at Tejpur. The firm completed the work and raised the bill for the same on 18/1/1993. However, the present appellants did not make payment. And as such, the respondent was compelled to request for arbitration to resolve the dispute. Stop. For the said purpose, the respondent also approached Delhi High Court on Delhi High Court seeking appointment of an arbitrator. However, said application was dismissed due to lack of territorial jurisdiction. Ultimately, on 26/8/2019, the District Judge Sonitpur appointed an arbitrator under Section 20 of the Arbitration Act 1940. Stop. It is pertinent to mention herein that the appellant husband, the husband of the present respondent expired during the course of arbitral proceedings, and the present respondent represented him as his legal heir in the said proceeding. Finally, the arbitrator, after hearing both the sides, made an award on 31/5/2022 in favor of the present respondent, and the present appellants were directed to pay a sum of rupees 1,33,47,267.92 paisa with an interest at the rate of 9% per annum till realization. So, it is further pertinent to mention herein that despite the culmination of arbitration proceedings, the arbitral award could not be published as the present appellant did not clear the dues towards arbitration fees. It was only when the present respondent, approached the Court of London District Judge Sonitpur by filing an application under Section 38 of the Arbitration Act 1940, seeking a direction to the respondent to the present appellants to clear its part of the arbitration fees, the District Judge Sonitpur, by order dated 21/9/2022, directed the respondents to clear the dues amounting to 47,212.33 paisa. It was also directed by the London District Judge Sonitpur that on clearance of the dues, a copy of the award shall be furnished by both the parties. it also appears that in pursuant to the direction of the order dated 21/9/2022, the present appellant did not clear the balance share of arbitrators' fees, nor did they collect the award by the date mentioned in the order. It is only on 18/11/2022 they deposited a check towards balance payment of the fee of arbitrator. Stop. Next para. Thereafter, on 10/11/2022, the present respondent filed an application under section 17 of the Arbitration Act 1940, on the basis of which 1940 before the Court of Learned District Judge Sonitpur for pronouncement of judgment according to the arbitral award. Stop. On the basis of aforesaid application, Miss J case number 61/2022 was registered. However, by its order dated 23/11/2025, passed in Miss J case number 61/2022, the Learned District Judge Sonitpur dismissed the application filed by the present respondents, holding it to be filed before expiry of the period of limitation for filing objection against the award. Stop. According to the Court of Learned District Judge Sonitpur, the limitation for filing objection against the award began only on 18/11/2022, when the formal notice of the award was received by the present appellants. It held that as the application under Section 17 was filed by the present respondent on 10/11/2022, it was filed prematurely when the 30 days period of limitation was still running. Stop. Being aggrieved with the finding of the Learned District Judge Sonitpur, the present respondent approached this court by filing a civil revision petition, which was registered as CRP number, civil revision petition number 138/2022. Stop. This court also what was the order of the CRP, date of the order?
Won't have lordship, but this one has dismissed, holding that it was premature.
Yes. What was the date of the order?
Date of the order is
27/3/2024, page number 64.
no 138.
138.
It is the 23/11/2022, your lordship.
Yes, continue.
Listen.
Finding of the learned district judge Sonitpur. The present respondent, by preferring an civil revision petition, civil revision petition number 138/22. However, this court upheld this court by its order dated
27/3/2024.
27/3/2024, upheld the order of the district judge and held that the respondent had filed the application under Section 17 of the Arbitration Act during the continuation of the period of limitation, prematurely before expiry of the period of limitation for filing objection against the same. Being aggrieved with the judgment of this court passed in civil revision petition number 138/2022, the present respondent approached the apex court and filed a special leave petition challenging the finding of this court. The said petition was registered as civil appeal number 47/2025, arising out of SLP C number 10621/2024. Stop, next para. By judgment dated 3rd January 2025, the Supreme Court of India, passed by the Supreme Court of India in civil appeal number 47/2025, the order dated 27/3/2024, passed by this court in civil revision petition number 138/2022, was set aside and the appeal preferred by the present respondent, was allowed. While allowing the appeal, the apex court held that the present appellant were sufficiently made aware about the awards filing on 21/9/2022, and therefore the 30 days period for filing objection against the award under Section 30 of the Arbitration Act starts, finishes on 20/10/2022. Stop. The apex court also directed, while disposing of the aforesaid appeal, the apex court also directed the learned district judge Sonitpur to take up and dispose of the Ms. J case number 61/2022 as expeditiously as possible, preferably within the period of 5 months from the date of the judgment of the trial, judgment passed by the apex court. Thereafter, the Union of India, that is the present appellant, filed an application under Section 55 of the Limitation Act 1963 for condonation of delay of 56 days in filing the objection against Section 30 of the Arbitration Act 1940. It is pertinent to mention herein that the application under Section 30 of the Arbitration Act was filed by the present appellants way back on 18/11/2022. On the basis of the aforesaid application filed by the present appellant, Ms. J case number 58/2025 was registered. Stop, next para. However, by order dated 23/6/2025, passed in Ms. J case number 58/2025, the Court of Learned Civil Judge Senior Division Sonitpur declined to condone the delay in filing the application under Section 30 of the Arbitration Act 1940, holding that the present appellant had failed to show sufficient cause for the delay in filing the application under Section 30 of the Arbitration Act 1940. And accordingly, the misarbitration case number 4 of 2025 was found barred by limitation and by order dated 23/6/2025, the said misarbitration case number 4/2025 was also disposed of. The aforesaid order is impugned in this appeal. Ms. A. Gayan Lanet, Central Government Council, has submitted that the trial court, while dismissing the delay condonation application filed by the present appellant, as well as dismissing the misarbitration case number 4 of the misarbitration case number 4 of 2025, has erred in not taking into consideration that the present appellant came to know about the award only when it received the notice on where is the you have explained in your error. Error. Round number 10 was
My lord, case number 7, para 10, my lord.
page number
7.
no, you have mentioned somewhere
Yes, my ground number is 14, my lord.
around 14.
Case number 53, my lord.
Illegally. On 18/11/2022, and accordingly it filed its objection within period of limitation within 30 days therefrom, that is on 16/11. When have you filed the
16/12/2022.
উপরত ভুল লেখা ভুল 18/11 আছে 16/12/2022. She submits that the impression that the period of limitation will run from 18 period of notice, the impression that the date of knowledge about the award will start from 18/11/22 was also reproved by the Court of District Judge initially in its order dated. Which order? First order.
Uh, 23/11/2022.
Page number?
58.
Dated 23/11/2022. She submits that even the High Court was also of the view that the period of limitation would start only after lapse of 30 days from 18/11/2022. She submits that when two courts have held the said view, the present appellant who are litigants also only are not supposed to know about the niceties of law. And as such, the delay occurred in filing of the objection under Section 30 of the Arbitration Act 1940 was not intentional. Neither it was due to any negligence or laches on the part of the present appellant. She submits that as it was held by the apex court, as it was only when the present respondent approached the apex court, it was held that the limitation will start from 21/9/2010. The appellant immediately approached the Court of London District Judge Sonitpur by filing the prayer for condonation of delay, by filing an application for condonation of delay. She submits that cause of the delay in the instant case was the wrong understanding about the law, as the petitioner, as the present appellants, like as the present appellants were under impression that limitation will start only after serving of the notice upon the present appellant on 18/11/2025 and not prior to that. And same view was also upheld by two courts. She submits that in the objection filed by the present appellants under Section 30 of the Arbitration Act 1940, the appellants have raised serious questions as regards jurisdiction of the arbitral tribunal to enter into the process of arbitration, to conduct the arbitration. Any other ground?
That is other ground that are not as per the terms and condition and contract, that is stated in from the.
As well as the pleas, like the arbitration was not conducted as per the terms of the agreement which was entered into between the husband of the present respondent and the present appellants. She submits that the arbitration case number 4 of 2025 is required to be considered on merit. However, it was simply disposed of on finding the same being barred by limitation. She therefore submits that the order dated 23/6/2025 passed in Miss J case number 58/2025, whereby the trial court refused to condone the delay of 58 days in filing the connected application under Section 30 of the Arbitration Act 1940 is required to be interfered with by setting aside the same, as well as and thereafter setting aside the order dated 23/6/2025 passed in Miss Arbitration case number 4/2025. She also praised that thereafter the then this will also have to be set aside. Miss 14, but prayer is not there.
My lord,
She also submits that
this automatically.
accordingly, the order dated 26/6/2025 passed in Miss J case number 14/2025 is also required to be set aside. She prays for directing the trial court to consider the Miss J case number 14/2025 afresh after taking into consideration the objection filed by the present appellants under Section 30 of the Arbitration Act 1940. Stop. On the other hand, Mr. S. Ali, learned counsel for the respondent, has vehemently opposed the prayer made by learned counsel for the appellants. He submits that the appellant, being Union of India, having a good legal team, cannot take the plea of ignorance of law and after the judgment of the apex court in the civil appeal number 47/2025, it cannot take a plea that it was under wrong impression that the limitation will start from 18/11/2025. He further submits that as regards the fact as to since when the limitation for filing objection under Section 30 of the Arbitration Act 1940 will start has been laid to rest by the apex court in its aforesaid above mentioned judgment, wherein it has categorically held that the present appellant were sufficiently aware of the fact of filing of the award on 21/9/2022. The apex court also, he further submits that the apex court also categorically held that the period of 30 days of limitation for filing application under Section 30 of the Arbitration Act would expire on 20/10/2022. Stop. He also submits that since the application under Section 30 of the Arbitration Act 1940 has been filed by the present appellant much beyond the period of limitation as clarified by the Apex Court. The trial court has rightly dismissed the Ms. J case number 58/2025. Stop. Learned counsel for the respondent further submits that since the objection filed by the present appellant under Section 30 of the Arbitration Act 1940 was initially not accompanied by any application under Section 5 of the Limitation Act seeking condonation of any delay, and since same was done only after a clarification to that effect came from the Apex Court, it was incumbent on the part of the present appellant to have sought for incumbent on the part of the present appellant to seek leave from the Apex Court for filing such an application for condonation of delay, which has not been done by the present appellant. He submits that apart from pleading that the present appellant, that is the Union of India, was under wrong impression about the date of notice and about the period from which the limitation will run. No other ground has been stated by the appellants in their application for condonation of delay, as well as in the instant appeal, justifying delayed filing of objection under Section 30 of the Arbitration Act 1940. He submits that the Apex Court in the case of Union of India and the others versus Bidar Near Industries, reported in 1994 Supplementary 2 SCC 696, has also made observation that the Union of India, most of the cases filed by the Union of India before the Apex Court are often barred by limitation, and the application for condonation of delay is made in a casual and routine manner without indicating the facts which would constitute sufficient cause to permit condonation in accordance with law. He submits that in the instant case also, no facts were indicated apart from pleading that the appellant was were under wrong impression regarding period of limitation, which would constitute sufficient cause to permit condonation of delay in the instant case. He submits that the trial court has correctly dismissed the prayer for condonation of delay. উপরত দিব learned counsel for the appellant অর্থাৎ learned counsel for the appellant has cited a ruling of the apex court in the case of Mulchandra versus Union of India within bracket 2024 INSC 577 in support of her submissions. And the respondent, learned counsel for the respondent, has cited following rulings in support, has also cited a ruling of the apex court in the case of Calcutta Municipal Corporation versus Pawan Kumar Saraf and another reported in 1999 to SCC 400 in support of his submissions. Anything left?
Yeah, one more judgment, madam, regarding 1948 limitation applies, madam, regarding that. When they
On the judgment by appellant. Messrs. Appellant Counsel. Messrs. SR Construction versus NP Ramakrishna Reddy. Reported in AIR Online 2000 SC 553. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the rulings cited by learned counsel for both sides in support of their respective submissions. On 29th, I will deliver. Heard so and so. Heard A. Gayan and so and so. List this matter for delivery of judgment on 29/5/2026.
but you'll be there.
Next month.
Timing item 10.
We don't have time.
Can it be taken on next Tuesday, Lordship?
Yes, it has to be because we don't have time.
My lord, in this quick one. Has it?
It is part heard.
Part heard, Lordship.
part-heard matter, we will give short dates. Otherwise,
Well, item number 14 is a long pending appeal, my lord.
all are long pending.
My lord, in respect to
May I
item
pay for
number
a
12.
date?
No,
my
just a minute, before only part-heard matter,
My lord,
But,
item 12 is part-heard, my lord.
part-heard we will give dates.
Lord, a short date, if it can be taken up at 2 p.m. because my lord, sir, 2-3 occasion because of paucity of time matter could not have.
2 p.m. when?
Any date, my lord, any short date at 2 p.m., my lords, if it can be disposed of.
No, just a minute, Mr. Talukdar, what is your case? Item number? Item number 10. Due to Ramesh dates also. Tariq Saab.
It is due.
Due to paucity of time, this matter could not be taken up for hearing. Please this matter as part-heard matter on 18th of June. And next part-heard,
My lords, item 12.
item 12. Due to paucity of time, this matter could not be taken up for hearing. Please this matter as part-heard matter on 18 June.
At 2 p.m., my lord, if it can be taken up at 2 p.m. 3-4 times, 2-3 times there has been paucity of time. It can be disposed of, my lord.
Now all can be disposed of.
My lords.
On that day, we will not fix any time. Okay, at 2 p.m.
2 p.m. I am obliged, my lord. My lord, in respect to item number 20, there is a stay operating any date, my lord, if it can be fixed. Item number.
Other matters, no dates will be given.
My lord, I know item number 14, my lord, I'm hard pressed. It is 2015 appeal, my lord. Let it be after a month, my lord, I have no.
Item number 14, June Saksun at the date. Testamentary appeal,
My lord.
25th June.
May I have your lordship? Your
Yes.
lordship, item number 22. Your lordship, I lost my son in the year 2015. Till date, I have not received a single penny. The 50%.
June Utsav,
23rd, can it be on 23rd?
just a minute.
23rd June.
23rd June.
Please, your lordship, item number 17 and 18. Lordship, this is 2015 matter. And it was before Justice Udo, and then it was for judgment, but duties unable in this court. So it was released and then fixed today.
Today we have not,
So today, the matter could not be reached, so date may be fixed.
it will go in the month of August. Date the
7 August.
27th August.
Wait, please, your lordship. In item number 23, kindly a date may be given.
Your lordship,
You take date from registry.
in the month of June.
No,
Even if it is after summer vacation, no objection to it.
August you take a date from court master.
Much of